Good morning. As my usual practice, I'm going to wait a few moments. I think some folks are still connecting through audio and things. So I will wait a little bit and then get started with our introductory content. All right, it's 9:01. I'll go ahead and get started with introductions. Good morning. Thank you for joining us. It's October 17th, 2024, and I'm Nicole Kinsey, the presiding hearing officer of the Administrative Hearings Office of the State Water Resources Control Board. This is the second pre-hearing conference on the pending petitions for change of water right permits 16478, 16479, 16481, and 16482 of the Department of Water Resources for the proposed Delta Conveyance project. This pre-hearing conference is being conducted by Zoom web conference and is also being broadcast live on the AHO YouTube channel. Both the audio and the video are being recorded, and we will post files of this recording along with the Zoom-generated transcript to the administrative record that is available on the board's FTP site. The YouTube recording will also be available on the AHO YouTube webpage. If at any time you're experiencing technical difficulties trying to communicate with us this morning, please send an email to the AHO at adminhrgoffice@waterboards.ca.gov. You can also use the Delta Conveyance Project email address. The AHO staff are monitoring both, and they can let me know that there are some technical challenges. Assisting me today are staff of the Administrative Hearings Office, as well as staff of the Division of Water Rights and the Office of Chief Counsel. And if at any time this morning, hopefully this won't happen, but if it does, if I'm experiencing some kind of technical difficulties and need to, and I'm not able to rejoin the Zoom conference in a few moments, one of the AHO staff will call a brief recess until we can sort that out. With that, I'd like to move to appearances. There are many of us here, so please bear with me while we move through this, but I would like to know for the record who is with us today. And if you would, please, I'll identify each of the persons and entities that filed NOIs either before the first pre-hearing conference or in advance of this one. And if you're representing the party, please unmute your microphone and state your name. If any of you are here on behalf of multiple parties, if you can let me know, that might be helpful as well, and let us move through this more quickly. With that, I will start with the California Department of Water Resources.
Good morning. Can you hear me?
Yes, I can.
Okay, thank you. We are actually all in a conference room together, so you will see us talking through NRHQ 07-214 Burning Room. My name is Ann Carroll. I'm General Counsel for the Department of Water Resources. I'm joined by my colleagues Ken Bogdan and our outside counsel, Steph Morris.
Thank you very much. And I appreciate you're all in a room together, and that's great. When you do speak, it would be very helpful, and I apologize for this, to for the Zoom transcript to state your name, because the Zoom transcript will just pick you up as Burning Room. So then we'll know. Thank you very much.
Oh, Hearing Officer Kinsey, just one more thing. This is Ann Carroll. I believe there might be an AI bot that is also included on the conference, so I just wanted to recognize that we've had that happen in the past where it is as transcription service.
Yes. That is the State Water Board's transcription service, and that is that yes. So we have it's an advanced version. My understanding, as a non-technical person, is that it's some improved version of the Zoom transcription, and that's something that we have retained and we use regularly for our proceedings. So thank you for that, but that is expected, and it hopefully enhances the quality of the Zoom transcript, although sometimes that's questionable.
Thank you.
Thank you. State water contractors.
Good morning, Hearing Officer Kenzie Miles Krieger, Counsel for the State Water Contractors.
Thank you. Good morning. U.S. Bureau of Reclamation.
Good morning, Hearing Officer Kinsey. This is Amy Oftenberg on behalf of the Bureau of Reclamation.
Good morning. Upper Merced River Watershed Council. Westlands Water District.
Good morning. This is Mary Loom for Westlands Water District.
Thank you, Ms. Loom. And it may just be me, but you are very faint. So if you can move, just be aware of that if you do speak. I may have you move closer to the microphone. Thank you and good morning. South Delta Water Agency, Central Delta Water Agency, Heritage Land Company, and Rudy Mooson Investments LP.
Good morning. This is Dean Reese for those parties. And I'm having some difficulty with my microphone today, so I don't know if you can hear me, but you may not be able to hear me after this. So, did it come through?
It came through just fine. So as far as I can tell, everything is in order.
Okay, thank you.
Thank you. Byron Bethany Irrigation District.
Good morning, Ms. Kenzie. Kelly Tabor from Somac Simmons and Dunn on behalf of Byron Bethany Irrigation District. And today I'm also here on behalf of the following parties: the County of Sacramento, Sacramento County Water Agency, the City of Stockton, Nagley Burke Irrigation District, and Pescadero Reclamation District number 2058. And my colleague, Ms. Lacey from my firm, is here as well on behalf of those parties.
Thank you. And I appreciate letting me know about all of those. Thank you very much. With that, East Bay Municipal Utility District. El Dorado Irrigation District.
Good morning, Hearing Officer Kenzie. This is Brian Polson on behalf of El Dorado Irrigation District.
Thank you. Good morning. North Delta Water Agency.
Good morning, Hearing Officer Kenzie. This is Austin Cho Downey Brand on behalf of North Delta Water Agency, as well as Reclamation District number 999, Reclamation District number 2060, and Reclamation District number 2068.
Thank you. Good morning. Placer County Water Agency.
Good morning, Dan Kelly, General Counsel, Placer County Water Agency.
Thank you. Good morning. Central Delta Water Agency.
That's Dean Reese here for Central Delta. I think we took care of that in the last.
I
I
think
think you announced, yeah, you did.
Oh, I did. I included it there and then I included it here. Yes, thank you. I apologize. Thank you very much. Let's see. There's a collective here and I'll let you march through all of them, but I'm going to start with San Joaquin County et al.
Good morning, Hearing Officer Kinsey. This is OSHA Missouri, and I am here on behalf of Contra Costa, San Joaquin, and Solano counties, as well as local agencies of the North Delta, Friends of Stone Lakes, David Elliott, Frank Loretz, and Worcester. And then I see also that my co-counsel for San Joaquin, Mr. Keeling, is here as well.
Thank you. Good morning. Steamboat Resort.
It could be Ms. This is OSHA Missouri again. Emily Papalardo may not be able to attend today, but I will be sure to report back to her about anything that affects her protest.
Thank you very much. Next, I have Buena Vista Rancheria of Miwok Indians, Shingle Springs Band of Miwok Indians, Winnemem Wintu Tribe, Little Manila Rising, and Restore the Delta.
Good morning. I'm Naji Thompson, and I am a student certified attorney with the Yale Environmental Justice Law Clinic. I, along with my co-counsel, Tara Bear, who is also a student certified attorney with the same clinic, will be representing those clients. Buena Vista Rancheria of Miwok Indians, Shingle Spring Band of Miwok Indians, Wintu Tribe, Little Militia Rising, and Restore the Delta. We're supervised by Stephanie Staffy, who's also on this call. I'd also like to take the time to open it up for my clients to introduce themselves if they'd like to.
Certainly, and good morning.
Good morning.
You're
Good
welcome.
morning.
Go ahead.
Good morning, Officer Kenzie. This is Barbara Berrigan-Priyo with Restore the Delta.
Good morning.
Good morning again, Officer Kinsey. Gary Mulcahy.
Good morning, Mr. Mulcahy.
Gary Mulcahy, Winnemem Wintu Tribe.
Good morning. Welcome.
Good morning, Crystal Moran, Shingle Springs Band of Milwaukee Indians.
Good morning.
Good morning, James Armento, Executive Director for the Cultural Resource Division here at Shingle Springs Band of Milwaukee Indians.
Good morning.
Thank you,
Welcome.
everyone.
Thank you. I appreciate that. I have next on my list here, California Indian Environmental Alliance. I don't see Ms. Norris with us. California Sport Fishing Protection Alliance.
Good morning, Chris Schutz for the California Sport Fishing Protection Alliance.
Good morning, Mr. Schutz. California Water Impact Network. Friends of the River.
Good morning. Can you hear me?
Yes, Mr. Wright.
Yeah. Yes, this is Bob Wright for Sierra Club, California, Center for Biological Diversity, North Coast Rivers Alliance, Friends of the River, Planning and Conservation League, and Save California Salmon. Thank you.
Thank you. Did you say also, good morning, Mr. Wright. Did you also say North Coast Rivers Alliance? I have that on my list.
Yes,
Also,
I did
okay.
say it.
You might have said, thank you. I appreciate that. Good morning. Pacific Coast Federation of Fishermen's Association and the Institute for Fisheries Resources.
Glenn Spain. I'm representing those two organizations.
Thank you. Good morning.
Thank you.
Golden State Salmon Association.
Good morning. This is Scott Artis with Golden State Salmon Association.
Good morning. Save the California Delta Alliance and Hood Community Council.
Morning, Hearing Officer Kunze, Michael Brodsky on behalf of Save the California Delta Alliance and Hood Community Council.
Thank you. Good morning. And I'll ask my team if we can update Mr. Brodsky's title here so our transcription will identify him.
Oh, sorry about that.
That's not, no, it's fine. We can handle it, I think, on our end.
Okay.
San Francisco Baykeeper.
Good morning, Eric Busher for San Francisco Baykeeper.
Thank you. Good morning. And Deirdre Desjardins. And then finally, I think we received a pre-hearing conference statement, but not an NOI as far as I know from Delta Legal Communities. Do I have anyone from Delta Legal Communities? All right, Mr. Spain, I see you have your hand up, please.
Yes, sorry to interrupt, but I do see Deirdre Desjardins sign in.
Hello, I am here. I was just trying to figure out how to unmute, and I apologize.
That I understand. Thank you and good morning. Mr. Moore, did I skip you or maybe I went too quickly and you couldn't unmute? I see your hand is up, but you're still on mute, which is let's see. Mr. Moore was here. Well, I will circle back. I see you're on, Mr. Moore, but if we'll circle back and see if we can get you off of mute so that you can introduce yourself.
Dan Whaley here for Delta Legacy Communities.
Oh, thank you. Good morning, Mr. Whaley. And Mr. Whaley, I don't believe we have a notice of intent to appear from you. It would be very helpful if you could send one in. There's a form that should be attached to the July 31st hearing notice. And it's just for appropriate contact information. And so we can add you to our service list. So that would be very helpful if you haven't done that already, to send one in.
I will do that.
Great.
I can't find one.
Thank you.
I will do that.
Is there anyone else on the call who has not had a chance? Thank you. Who has not had a chance to introduce themselves, who plans to participate in our conference today? Mr. Miliband, I missed you.
Oh, thank you. Good morning, Hearing Officer Kinsey West Miliband for the City of Sacramento and Diablo Water District.
Do we have an NOI from you yet?
Yes, filed earlier this week. So
I see. That's why I probably just missed it. Thank you.
my fault. Thank you.
And Mr. Moore, I see you're here, and I see you would be here on behalf of California Water Impact Network, and I see you're still on mute, so that may be our challenge. Sometimes spacebar works to take you off mute. I'm not sure. Or at the bottom, there should be buttons at the bottom. Or you could try calling in. That's my fun. I'm exhausting my Zoom knowledge. Well, we'll give it a shot. At some point, I do want to be able to hear from you. So if you may try logging back in or calling in on a separate line, that might be helpful. All right, with that, I'd like to go ahead and lay out what we're planning to talk about today, although it was in our notice. So the AHO, I think most of you are familiar with, issued a notice of public hearing for this proceeding on July 31st, and we held an initial pre-hearing conference on August 18th. The AHO issued a notice of pre-hearing conference on September 17th for today's conference, and that notice laid out some of the issues that I would like to talk about. I did receive a number of pre-hearing conference statements, so I was going to read those out just to make sure we didn't miss any. But I did receive statements, and again, I read them carefully. They were quite helpful and quite detailed, and I appreciate that. We received statements from the Department of Water Resources, state water contractors, the joint protestants, which included a number of signatories, and I appreciate that joint effort. Sacramento County et al., North Delta Water Agency, the Pacific Coast Federation of Fishermen's Associations and Institute for Fisheries Resources, Save the Delta Alliance and Hood Community Council, California Water Impact Network, the Buena Vista Rancheria of Miwok Indians et al., the Sierra Club et al., and Delta Legacy Communities. Are there any statements that were filed that I missed? I just want to make sure our record is complete and I didn't miss anything. All right. So the issues I laid out, which were in the notice for this pre-hearing conference, was to address whether the State Water Board should reject or accept the petitioner's August 23rd request to amend the DCP change petition. And that's not something I'm not going to make a decision or rule on it. I'm actually not sure that I'm the one with the authority to act on that particular piece, because I think the authority lies with the division and not the Administrative Hearings Office. But in any case, I'd like to talk about it, and I think talk through it. The next issue, which is related, but I think it makes sense to address subsequently, is can and should the State Water Board consider the DCP change petitions that have been filed separately from petitions for extension of time that DWR apparently plans to file at some point. A petition for extension of time of the deadline to divert and beneficially use water under the subject permits. Number 3 on my list was a more procedural discussion about whether to stagger the deadlines for submission of case-in-chief exhibits and case-in-chief hearing days, such that the petitioner would present their case-in-chief first. And then finally, we can turn to any other procedural issues that would be appropriate to address today. I think most of the detailed procedural issues about how the hearing will be run, we can get to in a subsequent pre-hearing conference once we have a more firm schedule. But if there are other procedural issues we should address now, and I know some of you raised some items in your pre-hearing conference statements, we can do that. With that, my intent is to go ahead and turn to the first issue. But is there anything else? Mr. Moore, welcome. You're off mute.
Roger Moore, belatedly on behalf of California Water Impact Network. I appreciate you acknowledging me earlier when I was having a few technical difficulties getting on.
Thank you. Good morning, and I'm glad we could work this out. So thank you. with that, anything else before we, and Mr. Moore, just a reminder to, if you're to put, yeah, there we go. That helps me. Otherwise I can't keep track of the Zoom. Anything else before we go ahead and jump into the first issue on the request to amend the change petition? All right. So I thought I'd give some background. What I tried to express, and when I issued the pre-hearing conference notice, my thoughts weren't entirely complete, but obviously I'd worked through some of these issues, and I've been thinking about them more and thinking about them in light of the pre-hearing conference statements, which were quite helpful. And I think what I was trying to express with respect to this request to amend the change petition is that, at least from where I'm sitting, I don't think it's necessary. So I want to talk through it and see if there's a path forward. But I don't think an amendment to the change petition is necessary to accomplish what I think the DWR is hoping to accomplish with that change. My understanding of the way construction deadlines function in water right permits, at least in California, is that they essentially serve as a diligence milestone. So if a project proponent, an applicant, permit holder fails to construct a project by the fails to construct the elements of the project that would be necessary to divert and use water under the permit, fails to do it by the construction deadline, then the right holder is then at risk that the State Water Board will hold a revocation proceeding for lack of diligence, right? So it puts you at risk for that. But my understanding of that is once a right is perfected, or at least a portion of the right is perfected, the construction deadline is essentially moot with respect to that portion because diligence is no longer an element of the water right. I mean, you still have the use it or lose it principle, but diligence is not a separate factor on its own. So one of the ways I was thinking about it is that if the board approved a change petition for a license, a water right license, it wouldn't include a construction deadline. The right holder can go forward with construction on as they see fit if the change petition is approved. So I wanted to talk that through with you, Ms. Carroll and team. I think here a new construction deadline would only be appropriate if we were also looking at a petition for extension of time. And if we're not going to do that, I don't think we need a construction deadline element here. And I think that's the path forward. And then on the flip side of that, if we are going to consider a change to the construction deadline, I think that the path for that procedurally is a petition for extension of time. And then we bring in those factors such as considerations of diligence and things like that. And that's a different fork in the road. So with that, I know that's a lot, but I wanted to give some background, and I'd like to just have a conversation because like I said, I think we can work through this one and hopefully come to a meeting of the minds, at least on what we understand, maybe what we understand the law to be. But I'll turn first to DWR, and then I'll look to maybe state water contractors next, and then go to the room, and we'll go from there. So Ms. Carroll.
Thank you, Hearing Officer Kinsey. So we agree if that is the most efficient way, we would like to go forward most efficiently. We understand, though, that it's only as to the perfected water right or the portion of the perfected water right that the diligence is no longer a function, but also want to make sure that it's clear that the amendment that we're seeking for this particular hearing and to be heard at this particular hearing is only for the construction term 6 and is not for the beneficial use, which is captured in term 7 of the water rights permits.
Yes, I mean, I think I understand. I think we're on the same page, and maybe we may come back around if it sounds like we're not. And that's what I think. This is sort of a rhetorical question, but my understanding is that if the State Water Board were to approve an amended permit or amended permits in this case, DWR that approved the change in points of diversion and rediversion, and it would then including also this limitation as in some factor, and we're going to have a whole hearing that will address this, but some term and condition that limits the Department of Water Resources to the amount of the maximum use prior to the beneficial use deadline in 2009.
Oh, you froze.
That water right,
Hearing Officer Kinsey.
did I freeze? Am I back?
You're back, but I
Okay.
think you need to back
But
up.
we may have lost some of my convoluted train of thought. I'll start again. Thank you. What I was trying to say in a very long way was, I think if the State Water Board approves DWR's request and issues amended permits, those amended permits, I don't know if it would delete term 6 because it's no longer relevant, or it could include a clarification to term 6 to explain, but I don't think we need a new construction deadline for DWR to construct the project with respect to the portion of the change that's with respect to that portion of the water right that's been perfected, in the sense that DWR will be able to operate, construct, and use the facilities with respect to the maximum beneficial use prior to 2000. I think is it December 31st, 2009, the deadline.
Construction is 2000.
The construction deadline was 2000, but the portion of the water right that has been perfected by 2009.
Correct, for term 7.
And then what would happen is that DWR would then at some point file a petition for extension of time. And if that were approved, that would likely include a construction deadline unless the project's already been constructed, in which case we wouldn't need it either, right?
Right.
If that makes sense. Okay. I'll let you ponder that. We'll come back around and see if I will turn next to state water contractors. If you have anything to add on this point. Mr. Krieger, did you want to comment on this conversation?
Briefly, and frankly, I probably need to ponder it a little bit too.
Mm-hmm.
But I want to suggest that the DCP, the petition is an additional point or 2 points of diversion and rediversion to the state water project permits. We're talking about the operation of those permits within the existing water supplies that are available to the state water project. And so I think that when we're thinking about the construction timeframe and the applicability there, we're talking about water that has already been diverted under the state water project. And so we don't necessarily need to venture into a perfected or unperfected consideration when we're talking about a term 6 amendment. But again, I would suggest that I need to continue to ponder it too, but those would be my comments for now.
Thank you. I will my intent is to go down the list from here, to go down the list of those of you from whom I received pre-hearing conference statements, and then I'll look to the larger room. So with that, Sacramento County et al. Are there any comments?
We would just reiterate the points in our pre-hearing conference statement, and any decision we're not aware that the request is to limit the use of the DCP to the historic use. I think we don't really know what that is, and that would be an issue that would have to be decided in the hearing. Our concern is that if the DCP change petitions are approved, even at whatever the historic use is, that future determination about the larger state water project and the availability of additional water will be prejudiced by the decision that's made to approve and construct the DCP, and arguments will certainly be made that given the investment in the DCP, that those any expansion and use from historic use should be authorized, and that would be very prejudicial. This consideration of the DCP in advance of the due diligence question and the expired water rights is putting the cart before the horse.
Thank you, Ms. Tabor. North Delta Water Agency.
Thank you, Austin Joe, on behalf of North Delta Water Agency. I also would refer to the pre-hearing conference statement that we filed. and just underline the point that the water code and the state water board's regulations do not provide a pathway for simply removing an existing permit condition that requires completion of construction by a particular date. So the proper channels need to be filed, diligence needs to be demonstrated, and the board needs to make those necessary findings to allow such a thing.
I want to make sure I understand that. Thank you, Mr. Cho. So it's your position that, let's say DWR came in and said, we're not going to file a time extension. We're just going to keep this permit with our maximum beneficial use. We'd like to process this change petition, and we're going to take the maximum beneficial use and walk away and be done with it. It's your position that the State Water Board could not remove term 6 from the permit as an unnecessary vestige of a moot point?
No, my position is that term 6 is an existing condition on those permits, and in order to extend the deadline that is there for either a deadline for construction or for completing beneficial use, the proper procedure is to file a petition for extension of time. And there, at the time that this change petition was filed, there was a pending petition for extension of time relating to DWR's beneficial use on file with the State Water Board. The removal of that petition in the pendency of this hearing just complicates the matter and removes that question of whether diligence has been exercised from the entire equation.
I think maybe we'll come back to this, because I think, what do you understand? And this is probably just bringing forth a point that is a point of maybe disagreement about what the law is, but what is your understanding of what term 6 does in the permit at this point? Is it your understanding that it prohibits DWR from constructing additional works?
In its express language, it says construction must be completed by December 31st of 2000. The fact that DWR has initiated this process of seeking to amend that term indicates a recognition that that operates as a constraint on DWR's ability to construct future new facilities under its permits.
Okay, thank you, Mr. Cho. Let's see, next I have Mr. Spain. Do you have any comments on this issue?
I'd refer to our statement, but I really do agree with Kelly Tabor and Simmons et al. Position on this one. I think it's pretty clear that to legitimately alter the now expired deadlines for beneficial uses, they would first, DWR would have to first file a petition for extension of time. And if that process were followed, that would clarify a lot of confusion here. And I'll leave it at that.
Oh, please go ahead.
Thank you, Officer Kunze. I'd just like to comment that as a practical matter, the construction deadline functions as more than a milestone for due diligence. I mean, we're 24 years past when those facilities were supposed to be completed. We're in a completely different era. Public trust considerations are completely different now. So, I mean, you're really, in essence, initiating a new water right, because you're saying, okay, well, we're going to go ahead with this. We're going to revive these expired permits in an era, which was not originally contemplated when the permits were granted, and under conditions which have substantially changed and were not originally contemplated when the permit was originally granted. That's just my observation.
I think, and thank you, Mr. Brodsky. I think I understand those points. Would you connect for me again the relationship between what you stated and this question about what the appropriate mechanism or the function of the, I should say, the function of the construction deadline in the permits?
Right. And so You were breaking up a little bit there. Was there an additional question to me, or were you just
And I'm
sort of
sorry, it seems like
repeating what I had?
everyone else is stable on my end, but it sounds like I'm not coming across as well for everyone else. So I apologize for that. My question was, if you, Mr. Brodsky, was I think I understand your points about the changes in circumstances that have occurred, first of all, since these permits were issued, and also since the construction deadline expired. Will you please connect for me again the relationship that you see between the construction deadline and those changes in circumstances and what the board should be considering here?
So I think that the construction deadline focuses on a constraint. Anything that's transformed sufficiently in quantity is transformed in quality. So we're just so many years past it that it serves as a marker that that permit is now expired, and to reinitiate it, to revive it, then you have to consider all the circumstances that are present now. Does it make sense to do that in light of current public trust considerations and all the other considerations? In terms of its relationship to the DCP, I think you have to know, will those expired permits be revived or not before you put together your case in chief for the DCP, because you don't want to start to present evidence in the DCP hearing with multiple possibilities of how much water might be diverted or not. I think it's also the case, if those hearings are not, if those expired permits are not revived, DWR may take the course of just simply trying to initiate a new water right for the DCP instead of as a change in the point of diversion, which then would be a completely different type of set of hearings, right? So you wouldn't want to start to go forward on a change in the point of diversion hearing and then find out, well, we're not going to revive the expired permits. And so therefore it doesn't make sense to build the DCP because, you know, we can't produce enough water through it. We've lost all the additional water that went out with the expired permits. And so we have to do this as initiating a new water right for the DCP, which is a completely different kind of hearing, right? With different requirements, different decision points on whether it's granted or not. So that's why I think it makes sense. Are those expired permits going to be revived or not should be decided before a date is set to submit the case in chief for the DCP. Now, whether you consider that a completely different, name that a completely different proceeding, or you name it as, you know, preliminary phase of DCP, in my view, maybe others will have a different view, and I can stand corrected. The factor is to find out, are we going to revive the expired permits or not before we deal with the substance of case in chiefs in the DCP.
Thank you, Mr. Brodsky.
I'm getting a message that my internet connection is unstable. Were you able to hear me?
I did hear you. I thought it was me, but I actually heard you fine.
Okay.
Thank you. Mr. Brodsky, just one follow-up question, just so I can be sure that I understand your position. Is it your understanding?
Okay.
Can you hear me? All right. I'll look to my team.
I
Is
can.
it
You're
me,
breaking up a little bit.
or is it Mr. Brodsky? Can you tell?
Here enough, Sir Kinsey. It is not you.
Okay. In this case.
I would recommend that.
Okay, I apologize. I tried to get to where I'm traveling. I tried to get to where I had a good connection, but apparently it's not as strong as I thought it was.
That's okay. And thank you, Mr. Brodsky. I heard you and I appreciate your comments. So we'll keep it there, and we'll circle back as needed, I think, on the next question as well.
Okay, thank you.
Mr. Kelly, did you want to jump in on that issue?
Yeah, hearing officer Kunze, I appreciate it. We didn't file a pre-hearing conference statement, but I guess there's a fundamental question that's been raised by the discussion that we're now having, and what I heard from, I believe it was the state water contractors through Mr. Krieger, is that the current petition only seeks to divert water that's already been appropriated by the Department of Water Resources through this new facility. My understanding is, from the documents I've reviewed and from the conversations that I've had with the Department of Water Resources, is that the project itself actually is geared towards taking excess water out of the system, which has not already been appropriated by the Department of Water Resources. And so I think it's going to be important to make sure that the record is absolutely clear as to what this project proposes to do, so that whatever decision that you and the state board ultimately issue will be very clear with respect to the water that's authorized to go through this facility. Thank you.
Thank you, Mr. Kelly. I share your, well, let me caveat. My understanding of DWR's petition, and this is, I agree, this is important to talk about. I was going to talk about it with respect to the second question, but I think now is as good a time as any. My understanding of DWR's petition for change is that DWR is seeking approval from the State Water Board to add points of diversion and rediversion for the full face value of their permits, with the understanding that they are not authorized to divert water in an amount in excess of what I'm calling the perfected portion, which may or may not be the maximum historic use that occurred before the beneficial use deadline in 2009. It's something we commonly refer to it as the maximum historic use, but there may be nuances there. And that is DWR's request. So it's not, the change petition here would, if approved, cover the full face value of the permit with both the perfected, what I'm calling the perfected and unperfected portions of the right. But that's probably an important point. I will, not right now, but Ms. Carroll, we will get back to that, and I will ask for confirmation that that is exactly what DWR is asking here, because I think that is part of the, I do want to be clear what we're doing here, and it is, these are very confusing issues, and it's at least coming to a mutual understanding of what we're doing is helpful. I do want to continue down the list. I believe I stopped just before Mr. Moore on my list. Mr. Moore, do you have anything to add on these issues?
I do, and I appreciate the opportunity. Can you hear me okay?
Yes, I can. Thank you.
Great. Kicking the can down the road yet again is not an option here. It is, I think, glaringly obvious from the combined pre-hearing conference statements and earlier objections to the minor change request that this is nowhere near a minor change to get a 55 year extension in construction without even attempting a change in beneficial use. DWR has taken the position in what it has filed, so the state water contractors, that the Delta Conveyance project is not going to be limited to something that it has not documented and demonstrated anyway, which is the demarcation line between 2009 beneficial uses and what's after that. But hearing the opportunity that you've teed up today, DWR is now trying to pivot and take the position that, yeah, we'll go forward here and do it conditionally. That will not work for the reasons that we have identified in our pre-hearing statements and earlier objections, both jointly and separately. I want to focus on a few reasons here why this pivot is just going to be untenable in this proceeding. DWR is attempting to alter or play along without seeking resolution of a construction deadline that expired in 2000 with a beneficial use deadline that expired in 2009. This is not a side issue or a minor issue. It goes to the fundamental question of whether there is a change that can be made that will give DWR what it is requesting here, or whether it would require a new water right. And it is clear that as the petition is framed, there is no way that DWR can get there based on the petition that it has and the support that it is provided. First, there's no evidence, DWR certainly hasn't shown any, that it ever put its permitted amount of water, I think it was 10,350 cubic feet per second, to beneficial use before the time that it expired long ago. DWR, however, premises the DCP on getting permission to divert an additional 6,000 cubic feet per second of water that were in no way supported or allowed under its prior beneficial use. DWR also never secured resolution of protests, quite a few of them that were filed in 2010 in response to its 2009 request for an extension, that were based on numerous legal objections, including failure of due diligence and additional legal obstacles. Finally, DWR's EIR supporting its petition here is expressed, and the board has recognized on page 4 of its notice that its environmental impact report, much like its change petitions, assumes the diversions under its water rights permits, and I'm quoting from page 4 of the board's notice here, would not be limited based on the amount of water used before the 2009 deadline to perfect those rights. I want to just point to, I appreciate you allowing me to go through these points. I want to mention a few things I haven't heard yet that I think it underscores the severe prejudice that would result from attempting to kick the can down the road here. First is the matter that DWR improperly, in violation of the board's ex parte rules, attempted not to file here, but that protestants did. It's August 21st, 2024 withdrawal letter of its 2009 extension request. That has been made part of the proceedings because it was introduced by protestants, which is, and it clearly is interrelated with the matters that are at issue here. What I want to point to in that withdrawal request is that the grounds that DWR itself outlines for the withdrawal closely parallel many of the issues that protestants have raised here. They include, among other things, and I'm quoting from DWR's reasons for its withdrawal, the enactment of the Delta Reform Act, the State Water Resources Control Board's ongoing efforts to update the 2009 Delta Water Quality Control Plan, and further understanding of the Delta ecology. By DWR's own recognition, what it is really seeking would require something that it doesn't have the basis to support yet. That cannot be deferred until later. That must be addressed now. If there were any doubt about that, it would be resolved by something else that CWIN referred to in its pre-hearing conference statements and other objections. And that is in May of this year, DWR published a draft environmental impact report on a separate track about long-term operations of the State Water Project. In that, DWR anticipated relying on still incomplete review to inform some future discretionary approval process relating to a water rights time extension. In other words, the conditions that TWR was recognizing in its withdrawal letter, it hasn't even figured out yet. And they go to the fundamental question of whether DWR has the water rights it needs to get a change here or would need to get a new water right. If we just pretended that this problem didn't exist, you would have what the protestants tried to raise in 2010 and what has unfolded since then without resolution by the state board. A slam dunk cold storage problem that would result in a serious legal violation under the rules of the California trout decision, among others. So we urge the board not to kick the can down the road and to address this squarely before there are proceedings on the merits on the change petition. And I appreciate you indulging me the time to go through these points.
Thank you, Mr. Moore. I appreciate your comments here. Ms. Desjardins, if you would like to jump in now, please.
Yeah, I wanted to raise an issue that I don't think has been addressed, but I think is foundational, and that's the coordinated operating agreement. The Bureau of Reclamation's petition, the Bureau of Reclamation's permits for Decision 990 assumed the entire unimpaired flow of the Feather River, 4 million acre feet a year. And the hearing officer asked the attorney for the Bureau of Reclamation if the department's plans, the state engineer's plans for development of the Feather River project would interfere with the Bureau of Reclamation's Central Valley project. And they said yes. And the hearing was recessed. And the Department of Water Resources and the Bureau of Reclamation worked out the coordinated operating agreement. And part of the agreement was to share shortages. So that was how they resolved the conflict between the water rights. And the issue is that the coordinated operating agreement has been amended so that there is no defined agreement between DWR and Reclamation about how water quality control plan standards, which are all of the beneficial uses in the watershed, will be met in a third dry or critically dry year. So there is no longer any such agreement, and the project requires not only authorizes diversion, but direct diversion, but rediversion of stored water in Warraville. And the Decision 990 stated the board finds the several units of the Central Valley project, as well as other units of the State Water Resources Development System, are a coordinated project which require coordinated terms and conditions in permits. The board further finds that the terms and conditions necessary to effect the coordination cannot reasonably be determined until decision is raised on other state and federal applications, and they reserve jurisdiction until time of license. But this is the can that's been kicked down the road, and you're not addressing it in the Bay Delta Water Quality Plan. And it's a huge issue because we know that in droughts, the projects have been saying they don't have enough water. They are asserting that they need to divert a minimum of 1,500 CFS. And if you look back at the history of the permit consideration by the board, there was no minimum diversion. The boards have junior water rights to the Sacramento settlement contractors, and it's just that conflict has never been decided. And it's a huge issue, as is the representation of water rights in the calcium model may completely disguise this conflict. So I don't know that unless the board considers this would be something that would be considered in the petition for extension of time, whether reclamation should go to license, how much water in the Feather River is really available, and the Sacramento Valley water contractors. The board is also punted on determining how much water is diverted under the Sacramento Valley settlement contractors' water rights. And this is a huge issue as well in droughts, and continues to be. But when stored water is diverted under reclamation, that's released and is diverted before it gets to the Delta under reclamation's water rights at the settlement contractor's point of diversion, it reduces the flows that are available. And you have projects that are claiming they have a minimum diversion need, but they have not been carrying over sufficient water to meet those needs. So there is a real nexus, and particularly with the huge increase in temperatures that we've seen with climate change, evapotranspiration is taking an increased share of water, and in the newer, hotter droughts we have, there's less water in the watershed. And if we have more decades like the decade we've just seen, these are going to be absolutely critical issues. So I know this is a new set of considerations, but I wanted to put them there. And I think they haven't been adequately addressed to date. I know the board's been in a difficult position, and there's something that would be addressed when looking at the existing permits in the petition to extend. And I don't think they've done that kind of analysis. I've been here, I've been commenting for since 2012 that they needed to have analysis of hotter, drier conditions that we're likely to see with climate change. I sent a letter to the Department of Water Resources in 2012 saying, I think the once in a 1,000-year drought in New Mexico could come to California, and the next year it did. And so we've got to deal with this. We have to grapple with what's happening to the watersheds from climate change, and we have to, I would urge you to really think about how those issues are going to be addressed, because I think it's a core issue. And if you look back at
Desjardins, I understand. Thank you. I understand your points. I did want to ask a point of clarification, which is I wanted to clarify that in this proceeding, the Bureau's water rights are not at issue. Their permits are not at issue. And I wanted to make sure I understand your point. As I understand it, your request is that the State Water Board consider in this proceeding the interaction between the State Water Project and the Central Valley Project, and how those impacts would, how those projects would be operated with the Delta Conveyance. Change.
You have a joint point of diversion in the South Delta, and they do exercise joint point. The projects do coordinate, and you also have in the original permits that they will coordinate and share shortages. And to meet the beneficial, that was the foundation of meeting the beneficial needs of the areas of origin, and not exporting water that is needed for beneficial needs for, fish farms, Delta communities, was that the Bureau and DWR would cooperate and share shortages and would take on this obligation. And
thank you, Ms.
foundational agreement has changed.
I understand. Thank you. I think you made your point quite well. Thank you for your comments. I still have a list. I'm working my way through it. I believe Ms. Thompson, I have you next. Do you have any comments on we're ranging somewhat afield, but you're welcome. There'll be other chances to comment. I will step through all of the issues, but if you'd like to jump in at this point, please.
Yes, I would, and as well as my co-counsel, Ms. Bear. We're still representing the Delta Tribal Environmental Coalition, who are made up of the 5 parties we previously mentioned. And I'd also like to note that in addition to San Francisco Baykeeper and Golden State Salmon Association, the California Indian Environmental Alliance also are party to the statement that we submitted. So I'll be hitting on a few points regarding DWR submittals, and then I'll be passing it off to Tara, who to Ms. Bear, who will address some of the things about term 6 and the expired permits. I think I just really feel like we might need to take a step back and look at the core of what DWR is asking the board to do in this case. DWR is asking the board to give it special treatment where the law does not allow it. It's asking the board to create loopholes where DWR would be able to sideline those who'd be most impacted by the Delta Conveyance project. My clients here today are represent some of the tribal nations and communities who are already bearing the burdens of an overexploited Delta waterways, and they've constantly been excluded from the decision-making processes time and time again. Today, they're merely asking the State Water Board to hold DWR to the law, and that begins with making sure that all parties, and especially state actors, are held to the same standards of the law. Anything else would effectively rubber stamp the continuation of extrajudicial colonial and racial violence against these communities. Now, turning specifically to question 1, I just want to reiterate what a lot of the protestants have currently been saying is that DWR is trying to edge around the rules here, and that this is a question about not about diligence, but about the law. There's no law that supports DWR's amendments to term 6, specifically, and being able to extend this construction extension without having to resubmit change petitions. The proper process would be to withdraw their change petitions and then to resubmit under Water Code Section 1701, because there's no basis for this idea that because that an extension is inherent in the petitions that they have currently filed. Currently, DWR has submitted this minor change request under 1700.4, and as acknowledged by yourself and numerous protestants, this section does not apply in this case. The purpose of that section is purely for water right applicants to change their application, and it doesn't govern changes to change petitions. And this improper procedure should be enough to reject DWR's request. And DWR effectively concedes this point, as in their own pre-hearing statement, they don't try to negate anything that is said about the interpretations of 1700.4. I also want to clarify that DWR is now bringing a new argument into this case through their pre-hearing statement and saying that it's implicit in their February 22nd change petitions that this construction should be extended. And we're here today saying that it is not at all implicit, and there's no basis in law that there should be an implicit statement or a clarification that should be allowed in this case. For starters, if it was implicit, DWR wouldn't have had to refile something to say that they need to change their change petition. If it's implicit, then there would be no need, and the change petition on its own would stand legally. In addition to that, there's absolutely no mention of 55-year extension in any of DWR's filings and in their petition at all. They don't point to anywhere within the filings that we should be able to glean this idea that there's a 55-year time period in which they should be allowed to extend their construction. And just to renote again that there is a proper way to extend this to seek a change in their change petition, and that would be to withdraw it and to properly resubmit it under Water Code 1701. But instead of doing that, again, DWR is asking the board to create its own separate legal pathway and effectively rewrite the law. And I mean, the implications of this are also important to note, because essentially DWR says, quote, by approving the petition as filed, it would implicitly improve the extension for construction, end quote. And if taken as true, this means that by simply mentioning construction at all, DWR would have the opportunity to receive any length of construction, any sort of extension they wanted without having to make their intentions clear to the public or to the board. They can simply just write in and they say, oh, well, we had conjunction mentioned, and we can just write in any number of years that they would want. And then finally, this is prejudicial to the protestants. That, you know, DWR has done this change after the protest period has closed and after this has already been submitted to the board. This bypasses procedural safeguards that ensure that the public and community have adequate notice and opportunity to comment on anything that DWR wants to do. And I'll pass it off to Ms. Bear.
Thank you.
Thank you, Ms. Thompson, and good morning, everyone. There are two critical points here from DWR's pre-hearing conference statement and remarks today that the board must address before moving forward with this hearing process. The first is whether DWR has valid permits that can be legally extended or modified to begin with. And the second is the need for DWR to clarify the exact nature of the project that it's proposing here. DWR's pre-hearing conference statement attempts to make this proceeding a lot more complicated than it needs to be. The first threshold question here is actually quite simple. Does DWR have valid permits that can be changed? No, it doesn't. DWR's permits expired decades ago, term 6 in 2000 and term 7 in 2009. And yet here it is 15 to 25 years later, asking the board to retroactively extend them. That's a clear violation of California water law, and it also sets a dangerous precedent for water rights management going forward. Imagine the consequences of allowing DWR to open this novel door. Going forward, you're saying that any former permit holder could say, well, we used to have a water rights permit decades ago, and so instead of jumping through the necessary procedural hoops to apply for a new one, we're just going to go back and revive that old permit from the past. DWR has not provided any legal authority, nor have we found any, that would allow the board to revive permits that expired 25 years ago. And the burden here is on DWR to demonstrate that their expired permits can be legally extended. The burden's not on the protestants or the board to simply proceed under the assumption that it can. If DWR can't demonstrate that its expired permits are valid and can be retroactively extended, which again would be a novel pathway for the board to endorse here, DWR has to withdraw its current petition and refile for new water rights. Otherwise, the board risks setting a dangerous precedent of encouraging widespread non-compliance with deadlines that are about the law. It's more than just diligence. And those deadlines exist to protect legal users of water, the broader public, and the ecosystems and the resources that they depend on. DWR's attempt in its pre-hearing conference statement to separate consideration of terms 6 and 7 that's legally and procedurally flawed. DWR claims that term 6 could be extended now, while term 7 could be dealt with in some future proceeding down the line, but that approach doesn't make sense. The board can't go back and revive a 25-year expired deadline. And if the hearings office does want to allow DWR to exhaust its options, as others have said, it can instruct DWR to undergo the necessary procedure to present an extension request for the construction deadline through the proper channels, but we maintain that there's no basis for proceeding that way and that would still be an inefficient waste of time and resources. I want to point to California Water Code section 1397, which states, the construction work shall be completed and the water applied to beneficial use in accordance with this division, the rules and regulations of the board, and the terms of the permit within the period specified in the permit. Again, it's not just about diligence, it's about the law. Another really important point that I haven't heard anyone raise is that we actually can't even be sure whether DWR even has the legal right to use the maximum amount of water that it historically put to beneficial use under those 1972 permits, because we don't even know what that amount is. We don't know what portion of the permits has been perfected. To our knowledge, no licenses have ever been filed under the 1972 permits per California Water Code section 1600, which requires water users to apply for a license to confirm their water rights after completing infrastructure construction and demonstrating beneficial use. I have to underscore that the public and the hearings office are legally entitled to know exactly what's being approved here. And to that point, something else that I think is equally troubling, as Mr. Kelly and Mr. Moore raised, is DWR's failure to provide a clear and certain description of the DCP. In its pre-hearing conference statement, DWR has suggested that the DCP could proceed without increasing water diversions beyond historical levels. And that represents a major and unexplained shift from the DCP's stated purpose. As others have raised, the change petitions, operations plan, environmental impact report, and other documents all describe the DCP as a project that's designed to divert up to an additional 6,000 cubic feet per second from the Bay Delta, allowing DWR to operate the state water project at the maximum level listed in their expired permits of 10,350 cubic feet per second. This discrepancy raises serious concerns about the project's scope and the legality of the board's approval process. CEQA requires a stable and certain project description to ensure proper environmental review, and yet DWR's shifting narrative here leaves the board and the public unclear about what is being proposed. Is the DCP a substitution for aging infrastructure, or is it a project that's designed to capture excess flows to significantly increase water diversions from the Bay Delta? Those are two very different scenarios with vastly different implications for the environment and affected stakeholders, and also for the continuation of this hearing process. Like Mr. Brodsky said, protestants can't be expected to perform detailed analyses, such as providing evidence of public trust impacts for two different project circumstances, one in which the DCP would divert a significant amount of additional water and one in which it will not. So I'll just finish up here quickly by emphasizing that the stakes are high for this clarification. The DCP as it's proposed right now has significant environmental, legal, and procedural implications, especially for fragile Bay Delta ecosystems, their adjacent historically marginalized environmental justice community, and for tribal nations who rely on the Delta for cultural, subsistence, and ceremonial practices. The board can't approve the DCP without fully understanding how this increased diversion will impact water availability, flows, and the overall health of the Bay Delta watershed. And those impacts can't be adequately assessed until the board completes the Bay Delta Plan update and a comprehensive water availability assessment. The bottom line here is that the board has to address whether the 1972 permits are expired head-on before proceeding to case in chief, and it must require DWR to clarify the nature of the DCP. Proceeding with the hearing under these uncertainties would have serious legal, environmental, and procedural consequences. And I would now like to give our clients who are on this call an opportunity to chime in if they wish.
Thank you, Ms. Baer. And I'm looking if there are those who want to chime in, represented by Ms. Baer and Ms. Thompson. You're welcome to.
Looks like not.
Not right now. We can come back. And thank you, Ms. Thompson and Ms. Baer. I first want to acknowledge any law student who's willing to jump into water law is that's impressive. So thank you for your courage on this project. And I also appreciate that that not only is water law complicated, but California water law in particular is like all the complexities of any other Western state combined into one. So that's certainly an element here. And I assume the Yale Law School teaches many things well, but water law, at least in my experience, is not one of them. So welcome. I want to make a point of clarification. I think from your later comments, Ms. Baer, we may be on the same page, but just to make sure that for those who are listening, I want to make clear my understanding of what the law clearly is, which is that DWR's permits that we're discussing here today, these are water right permits that do not expire. They have to be revoked if they to go away, so to speak. The deadlines, of course, terms 6 and 7 are deadlines and they have expirations dates in them, but the permits remain unless and until the State Water Board takes a revocation action, and that can either be done through a petition for extension of time and considering that issue, or through a notice of intent to consider revocation, which neither of which we have before us right now. And of course, I understand part of the protestant's point is that's exactly the problem. But I just wanted to clarify that my understanding is where we stand now, revocation is not an issue that's live in this hearing unless something were to change. So I did want to lay that out there, and we can, as I said, this is not the end of our discussion, so we can come back to that. I also, just as a note, I very much appreciated your point about the risk of encouraging widespread non-compliance with deadlines. I think that was the term, I jotted that down, which for those who practice in California water law will find very amusing, because that's a huge challenge for the State Water Board. And I think it's one of the reasons this office was created, and the purpose of this office is to conduct the hearings that are necessary to enforce compliance with deadlines. But that has not been the state's practice very well. So that is an issue to grapple with here, and I understand that that's a tough one. I still have folks on my list to turn to. I believe Mr. Wright, you are next if you have anything you would like to add.
Thank you, but no, I'll be talking later when you get to other issues, of course, about the need, which was just mentioned by Tara Bear, to update the Beethoven plan, but I have nothing to add now. Thank you.
Thank you, Mr. Wright. And then Mr. Whaley, I read your statement that you submitted and your reference to the attachment with respect to the validation action that's pending in court, or, well, there's a judgment as I understand, but and that submission, but do you have anything to add on these other points? And I think if there's anyone else in the room who would like to speak on this, even if you didn't file a pre-hearing conference statement, you're welcome to raise a hand. Ms. Meserve, please.
Hi. Oh,
I'm sorry. Was that Mr. Whaley?
yeah, I was just gonna add a short thing. I think it's important to read that decision in the validation action, because it goes back to the fact that they haven't really identified, or they've sort of mischaracterized what they're doing, and they don't even have funding for it. But I would also note that all these counties that are involved, if you have a permit with the county and you don't comply, you have to start over. If you don't have it inspected, if you don't have it done according to the terms of the condition, you have to start over and pay for the permit again. And so I think that's a very good guideline that you guys should take a look at before you go forward on a bunch of this stuff. Anyway, thank you.
Thank you, Mr. Whaley. Ms. Meserve, we'll turn to you next, please.
Thank you. Can you hear me all right?
Yes, thank you.
Okay. Yeah, I think we're all there's a lot to take in here. And I do appreciate the remarks you made at the beginning, and as well as the opportunity to talk about these issues. As you probably know, there is litigation pending regarding the propriety of Water Board moving forward with processing this water right change petition while the petitions for extension of time were pending. The ground has shifted a bit with some of the maneuvering that we've seen in the last month or so from DWR. But fundamentally, I mean, I think a lot of good points have been made. I guess the big picture items that I see is that still, as has been mentioned, legally and procedurally, the process that's being not proposed, but suggested might be possible here just doesn't have a legal bearing. And also, I think there's a big concern about even-handed application of those requirements. And as the joint response that I worked on with others points out, and I think our former joint response did as well, and our complaint in court regarding this issue points out, the Water Board has been very able to enforce due diligence requirements with respect to other entities in Mendocino County, San Joaquin County, and other places. And so there is a concern about is there a level playing field here? I think, having survived the 3 years of water fix hearings without getting to a conclusion, obviously my clients don't favor the new tunnel or the new diversions, but I don't think any of us favor a waste of time. And I guess I think that we are all, fairly intelligent, and could, potentially make this juggle that's being suggested by DWR and try to suspend disbelief and, go down this kind of, I mean, it's already a complex project, okay? There's the physical aspect of it, and then there's the operational aspect of it. And the hearing will be addressing both of those things. And like I said, it took 3 years and I believe over 130 days of hearings last time. We were kind of close to the end, maybe, at that point. But, one of the things that I think is the operations plan, right? We do have an operations plan that DWR prepared, and it kind of is like suggesting that this Maserati is going to go 5 miles an hour all the time, so we're very skeptical, of that. In addition, we do see in the EIR, it's saying, hey, we're going to get on average 500,000 acre feet more per year from SWP than we do now. So, we spent a lot of time in the water fix hearing about there was this boundary 1 and boundary 2 thing where it's like, oh, will you drive the Maserati 5 miles an hour? Or will you drive it 100 miles an hour? And let's look at this range. And then, it was very confusing and difficult for all the parties to try to gauge what the impact on the fisheries, the other legal users of water, so it's very, as was mentioned previously, having something stable is important. And the fact that, DWR has this 5 mile an hour operations plan for what I would call a Maserati, like it says right in the plan, it can be changed, right? So, that's very concerning to me, because if I had use a little calculator, and if you ran a 6,000 CFS diversion 365 days a year all the time, which I know is unlikely and not the plan, that's 4.3 million acre feet of water, right? And that's more water than the state water project has ever diverted, right? So we need to, in order to process this petition, we need to know what DWR is proposing. And it can't just be, what it might do, what it's saying right now in order to look real good. And we don't have, and then plus we have the temporary urgency change process, which is a sore point with all of us in the Delta. So, and I think there's also an issue about if we were to assume, okay, we're going to, we'll go forward with the water rights process, but we can only permit up to the amount that's already been put to beneficial use. I'm not even sure that DWR knows that number. I guess, that's a question I have to DWR, is what they can tell us about that, because the way they report their water rights, they combine a lot of different rights together. And there's rights that are exercised down in the South Delta right now that could not be exercised in the North. There's only, I think, 4 permits at issue here in this proceeding, and there's more than that in the South. So because of the complexities of doing the reporting and whatnot, like it's not as easy or as simple as, if you had a diversion, because like I looked at, for instance, okay, in 2010, 16479 permit, they say they stored 2.7 million acre feet with a rate maximum of 5,888, but that's just one, and so anyway, I mean, I think that's a question that maybe DWR should tell us what they think that perfected right is. But I would say that's a totally big difference from what's in the EIR, what's in the application before you. And, I just think we need to set the table properly for this proceeding, because it's going to be tough. It's going to be really tough for everybody. And there's a lot of people that don't have a lot of resources that have a big stake in this. And so it's already hard enough to participate meaningfully. And I think if we take any, last time around, the hearing officers decided to ignore the issue of the petition for extension of time sitting there. I don't know what kind of legal issue that would have been in later judicial proceedings that, likely would have followed. But, I think getting the everything set properly, and then moving forward, that's the water board's job, and I'd ask you to do it. Thank you.
Thank you, Ms. Meserve. I appreciate your comments. Mr. Busher, please.
Yeah, just briefly add a couple of things. I have to confess, I'm sort of baffled by the suggestion or the idea that we should proceed in this hearing based on the water that has historically been put to use, whatever we do or do not know about that volume, because that's not the entire rationale of the project from DWR's perspective is to divert additional water than they have in the past or could in the future with existing infrastructure. And I don't think there's any analysis in, the documentation in the record here, in the CEQA documentation, in the ITP application of the costs and benefits of building a new tunnel and new conveyance facilities if you're not going to divert more water, or the consequences of building all of those things if you're not going to divert more water. So that's not, what is at issue in this proceeding. That is not what is at issue in the project. And I'm very confused as to why we would move forward and analyze the water rights that are not at issue or sought by DWR. So that's the first kind of point I wanted to make. And the second point I want to make, and I think this, our protesting parties had objected at the outset of this process, even before the changes that have happened since August, that this is and needs to be treated as a new water rights application. And I think that this entire conversation that we've had today kind of illustrates the necessity of doing that procedurally correctly. So there are statutory and regulatory procedures, like those that Ms. Baer and Ms. Thompson identified, for answering all of these questions that have come up since August about what portion of the water right is perfected or licensed, right? About what terms in the water right, in an existing water right, should be changed or extended, right? None of those procedures are to do it ad hoc through the pending change petition that DWR filed. And so I think we have a pretty stark choice here, right? Which is, one, whatever questions need to be resolved before a new water rights application is filed need to be resolved through their own appropriate statutory and regulatory processes. And then this process needs to happen based on a new water right application. And then the last thing I'll say is, one of the consequences of the procedure that DWR has offered, and that, comes from this confusion about how much water they are asking the state board to approve they be allowed to divert. DWR says we want to divert more water, and there is, right, what they call excess water available. But because it's a petition for change of point and diversion, there's no water availability analysis connected with that, right? And so not only do we not know how much water right they actually have a right to divert now, or how much they have, or whether those have expired, or whether they need to be amended. We also don't know how much of the water that they want, more water they want to divert, is available, because they didn't do that analysis as part of this petition. So I think that we can kind of cut through a lot of this if we recognize this is an application for a new water right and treat it as such, and use the existing and appropriate regulatory and statutory processes to resolve all of these other questions before we get to whether they can divert new and more water. Unless you have questions, that's all I have.
Okay, thank you. I was giving you time to think while I was thinking.
No, I appreciate that.
I do have a question, and I'm trying to, let me see if I can articulate it. When you in asking for a new, or suggesting that the appropriate process for this is a new water right application, that would be with respect, what happens to DWR's existing permits?
I I think that's a question.
How would
for the
that relate to
department.
the new application? I guess it
Yeah,
might
so
in your mind.
no, I'll give it a shot. I mean, I think that's a question for the department in terms of what they want to accomplish. But
Well,
as part of their water availability analysis, I assume that they would say, we currently have a right to divert X amount of water. So that is right available for our diversions. And there is also excess water available. They may say that they only need a new permit for the additional amount that they intend to divert and want to rely on existing permits for the amount that has historically been diverted. I don't know that we know the answer to any of those questions, right? Kind of the predicates as to what DWR views as necessary in the change petition or in a water rights application, because the only thing we really know is they want to divert more water than they have and currently do. And, you know, how that interaction unfolds, right, with partial existing rights and partial new rights in the future, or with, right, entirely new rights in the future because the existing ones expired 2.5 decades ago. That seems like those all seem like the questions that we need to be addressing in the application process that are just completely dodged and avoided by, you know, the extension request and the withdrawal of the extension request and the minor change petition and the implicit construction deadline change and all the other avenues that DWR has attempted to try to get around the required statutory process.
Thank you, Mr. Busher. You're not off the hook yet. I appreciate this. This conversation is helpful to me, so I think it's helped me think about this. At least, so let's, and I'm going to be clear. My understanding is this is I'm about to put out a hypothetical that is not the reality we're talking about. And I think I already raised this hypothetical, but if DWR came in and said, look, here's the number that we think is our maximum historic use prior to the expiration in 2009, and we're willing to, we ask you, State Water Board, to make that the new face value of our permit. We're willing to forego the rest of it. In that circumstance, my understanding is that, and they want to construct the Delta Conveyance project or something like it, the appropriate procedure for that would be a change petition. Would you agree with that?
So in the absence of any of the other expirations or issues that have occurred in the prior 50 years with those water rights, yes, I think that's right. I mean, if we assumed that there were licensed and perfected water rights for 5,000 CFS, and they said, instead of diverting from point A, we want to divert 5,000 CFS from point B, and we want no more, right? That sounds like a change petition. That also doesn't sound like this project, but that sounds like a change petition.
Thank you. That's helpful. I appreciate that. And I appreciate the caveat that we're speaking in a hypothetical alternate situation. I don't think anyone thinks that is the situation here, at least, yeah, as far as I understand. Is there anyone else who would like to jump in now? Once, as I said, there will be, this is not the end. I would like to keep, at some point we'll take a break, but I would like to keep going. Mr. Moore, please go ahead.
Just one further point for now, since the question has come up about, if notwithstanding its inconsistency with the actual petition and support DWR has provided here, there can be some way to finesse that based on a concept of perfected parts of the rights that remains to be determined. I just want to mention this is one thing that underscores the strong interconnection CWIN and a number of the protestants have raised with what is directly at issue in the parallel and pending phase 2 Delta water quality proceedings, where among other things, the board staff in its supplemental, in its SED last fall recognized on page 19, if people want to look at it, what is an acknowledged, and we appreciate staff's acknowledgement of the historic and continuing problem of massive oversubscription in the Delta, where among other things, the staff report said average regulatory minimum Delta outflows are only about 5 million acre feet, or about a third of the current average outflows, and less than 20% of average unimpaired outflows. Cutting through the data crunching and the legalese, the crux is it's not as if there's a stable status quo of perfected water rights that we could lean on here, even if there were the evidence to support it. There is a downward spiral that the legislature even acknowledged in the 2009 Delta Reform Act. So my protesting colleagues here who have said we need the public's concerns, the evidence about this that is currently non-existent to be taken seriously, and that tribes and others that haven't been heard enough from in board and other state proceedings as well, these voices need to be heard, and this needs to be carefully considered, not summarily finessed.
Thank you, Mr. Moore. I'd like to turn back to DWR and the state water contractors. If you have comments on, I know we've strayed beyond to a fair extent item 1, although I do plan to go explicitly to item 2, but on item 1 with respect to the construction deadline, is there anything, I'll look to Ms. Carroll and team, is there anything, we've heard a lot. Do you want to add anything to this conversation?
Yeah, we'll be very brief. And we're going to limit our comments to procedure and the questions that you've asked in the hearing notice. But by not addressing all of the comments made, we are not agreeing with those that have been made today during the pre-hearing conference. We've not put term 7 or beneficial use before the water board. We put forth term 6 and the construction deadline to increase the efficiencies and to make sure that those issues were heard before the board and with the interested parties. There is a utility to this Delta Conveyance project and its construction that will happen even if we are limited to our historical maximum use, which we have stated that we agree that that is our limit by law. So our permits are not expired. They remain in effect. And we hope that we can reach a efficient hearing process to move forward for the construction of the project.
Thank you, Ms. Carroll. Go ahead.
Sorry.
Go ahead.
The other thing I wanted to confirm is at the beginning of the hearing, you stated it was your opinion that term 6 wasn't necessary to be included in this hearing process, but will that be confirmed in an order from the board? Or how will we have affirmation of the decision?
And that's something I've been thinking about. I mean, that's a larger, but because I can understand if we go forward, if you were to withdraw your request on that, based on, you would want some documentation of the opinion of the State Water Board. So I understand that, and we can, if we end up going in that direction, we can discuss that further. I did want to ask about this question of the historical maximum use. I think the protestants beat me to it, but I had already written down this question of what it is. I think no matter what direction this hearing goes, we will need to know what that number is. And I wanted to find out whether the DWR has it with respect to each of the permits. When you plan on submitting it, what is the status of the historical maximum use for each of the permits at issue?
So we'll be presenting evidence in our case in chief. If those are interested and would like to construct it themselves, we also do report our water usage to the State Water Board.
Well, Right, but what, so in your case in chief, you will submit the number numbers, I think it is, that you think should be included as a permit term as the maximum amount that DWR can divert under its permits unless and until a petition for extension of time is granted. Is that right?
Very close. We will have those numbers to show what our historical maximum use is, but we don't believe that we need a permit condition because we are bound by law to not exceed that limit. So it doesn't necessarily need to be included as a permit condition.
I see. But you will present the numbers.
Yes.
Thank you. And then, with respect to this demonstration, I think I tried to articulate this in the way I articulated question 2 in the pre-hearing conference notice, which is, I think if the board were to proceed without a petition for extension of time, the board would need to consider, first of all, whether to approve the petition for change if a time extension is granted, and then also whether the board should approve it if a time extension is not approved, which would mean that there would need to be evidence in the record that the project is in the public interest. The board would consider the evidence in the record, whether it's in the public interest with a time extension and without a time extension, as 2 separate pathways. And I just wanted to confirm our intent is to present evidence with respect to both possible future worlds. Does that make sense?
I believe so.
Event again, apologies.
Okay.
Yes, I believe that is correct. The EIR analyzed both without the limitation. So if you analyze without the limitation, thus with the limitation, it would be even more conservative.
But a public interest finding could be different.
Oh, yes.
I don't know, but it could be different, right?
It should still be more conservative, because if we're analyzing a larger picture and the entire extent without the historical maximum beneficial use limitation, having more, then arguably it would still be more conservative for the public trust issues also.
Thank you. And I was actually asking about public interest. So for example, I remember the water fix proceedings too. And I remember we spent a long time hearing about the noise. This is a small piece of it, but the noise involved with pile driving as a public interest factor, right? It was going to be, it would be loud for a long time. So I can see here, I mean, on the one hand, you'd be weighing, well, you're going to have loud, this is a very microcosm, but just for example, the loud noises from pile driving as weighed against a project that will not increase the amount of water that can be consumptively used versus a project that will increase the amount of water that can be consumptively used. That balancing may be different. I don't know. That was just a small example, but do you understand where I'm coming from on that point?
I do, and I think we're going to have to be fact specific, but just to that example, I mean, construction would be the same with or without the time extension addressed.
All right, thank you. And I just had, I'm going to keep asking questions. I had a list of questions, so I appreciate you tolerating me here for this. I did want to get more clarity. In your pre-hearing conference statement, you mentioned that addition of a time extension petition would expand the scope of the hearing and would bring in additional issues. And I certainly appreciate that with respect to the diligence element that is inherent in a petition for extension of time. I wanted to check with you and see if there are other items, other issues that you think would necessarily be brought in with a time extension petition that we can reasonably, I don't know if this avoiding makes it sound like we're avoiding it on purpose, but that would not be brought up is currently framed.
I don't, to use your words, I don't think we could avoid bringing in additional issues if we are addressing term 7, which is why there's the limitation just to term 6, which is specific to the Delta Conveyance project construction. And it's the only project currently envisioned for construction for diversion, rediversion.
But if you bring in term 6, well, this goes back. It actually brings up a point I wanted to clarify. If we're going to address term 6 and, for example, alter term 6 to add in 55 years to the construction deadline, wouldn't that raise the diligence question? I mean, I think the statutory pathway to change a construction deadline requires the consideration of diligence, or is that not DWR's position?
It would be the diligence for the construction of projects. It wouldn't necessarily be the diligence for the beneficial use.
What's the difference?
The difference is the actual use of the water versus pursuing construction for the facilities.
So when considering whether to extend the construction deadline, the board would consider whether DWR has been diligent in constructing the project?
Or attempting to construct.
Okay. And then in addition to diligence, are there other issues that you see raised by considering term 7?
Yes, I mean, term 7 would apply to the operation of the entire state water project, not just to the operation of the Delta Conveyance project.
Can you be more specific? Help me with that one. Because the permits at issue here, these 4 permits, and you're seeking a change petition for the Delta Conveyance. So in a petition for extension of time, or if we were addressing term 7, that would require the State Water Board to consider diligence. We talked about that one. And what else with respect to, so all of I guess the concern would be environmental impacts that are not related to the Delta Conveyance project?
It would also be
one example.
Correct, that would be one example, but the other example is also the upstream storage regarding the operation of Oroville, which is not currently within the scope.
And based on that conversation, I think it's DWR's position that the final EIR for the Delta Conveyance project would not cover any action by the state board with respect to term 7. Sorry, is that I see you nodding, but that's a yes for the record.
I'm sorry, correct. I wasn't loud enough.
And that's because there would be potentially additional environmental impacts that would need to be assessed.
Correct, and operations, I mean, we would have to put forth additional evidence that we're not prepared to do so for this hearing process.
All right, let's see. And then this is a minor follow-up, well, relatively speaking, minor, because these things are so hard. I think when we last spoke, as I recall, or I noted down an expectation that the incidental take permit for the project from CDFW would likely be forthcoming in October. And I was wondering if there's any update on that timing, whether you have it or if there's been a change in the expectation that you are aware of.
Check, I want to make sure I say this accurately. We do believe that there is going to be a brief delay, but that's in the matter of a couple of weeks. We still anticipate it to be issued in November.
Okay, thank you. That's I will now turn to the room. Mr. Schutz.
Thank you. A couple of points. First, it seems appropriate to me that DWR should present the numbers that it believes it has put to use under its existing permits now. It should have done that in its original application. It should have done that when I requested it in 2010, and they wrote back to me and said, DWR wrote back to me and said it couldn't do that. They've had 14 years to figure it out. And if we're supposed to present evidence and testimony regarding what the impacts are going to be on in-stream resources of the proposed action, knowing what the limits are is essential to doing that. So I would request that you ask DWR to present that information prior to commencement of the hearing, the actual physical part of the hearing, and prior to the deadline for presentation of testimony. Also, I think it would be important for you, that something that's come up in the conversation you just had with Ms. Carroll, there is the sense, and I think it's a contested question, how much of the existing permits are at play in this hearing, as opposed, because after all, the request is to modify existing permits, not for a new water rights permit. So how are such things as storage in Oroville, at least insofar as it relates to potential changes to that storage in light of the availability of the DCP conveyance facilities? What is the scope of the hearing? DWR, in both its EIR and in what I'm hearing now and what I've seen in its application, are seeking to exclude those sort of upstream effects. And it would be helpful, in my opinion, to raise that as a hearing issue at minimum, in order to understand sort of what the scope of testimony is going to be, rather than assuming a priori that all of that information and all of that discussion is outside of the scope. That's it for now. Thank you.
Thank you, Mr. Schutz. And Mr. Moore.
Can you hear me okay? Having a
Yes.
little technical difficulty again. Okay, thank you. I strongly agree with the comments that Mr. Schutz just made. He covered some of what I had wanted to mention. The critical missing information regarding uses certainly should have been provided at the outset if that was going to be the foundation of this proceeding, rather, and in contrast to what DWR has presented, it should have been available before the deadline for protests, and also speaks to the pretty severe prematurity of assuming a January deadline for case in chief, particularly for protestants who haven't had that information, which may or may not even exist. But DWR has now represented that it will be attempting to present for the first time. Just for now, the other thing I wanted to briefly comment on was I appreciate the recognition from DWR's representative here that that, as seemed to be the case, the EIR does not analyze the Delta Conveyance project with the suggested limitation and distinction between perfected and non-perfected uses. But if they were to shift to that, it would create a massive problem of prejudice to the public that haven't had access to that information yet. And as other protestants have said, it would mark a fundamental shift in the proceedings that we have here. DWR's representative made what I thought, is a superficially plausible, but I think extremely flawed suggestion that that if the EIR did its analysis without assuming the limitation to 2009 perfected rights, that it would be obviously more conservative and more protective of the public if the proceedings ended up with that limitation. That is definitely not the case in context, because it goes to precisely a lot of the things that will end up affecting whether this matter is in the public interest or not. It may well turn out to be the case that if the problems relating to oversubscription that I mentioned, historical uses of water rights, and the paucity of proof of what has actually been perfected and what is not, once that information is vetted and evaluated, it may well be the case that the 20 billion plus project that DWR is claiming to be in the public interest could turn out to be a stranded asset that is not able to lawfully or economically operate. Ms. Meserve made a very, I think, important point in her analogy to a Maserati that would be limited to 5 miles an hour. The validation action was mentioned, and it presents the further wrinkle that we currently have we don't have the foggiest idea how the Maserati would be paid for. And what ratepayers and maybe taxpayers might be stuck with the bills.
Thank you, Mr. Moore. Ms. Desjardins.
Thank you. I just wanted to say that the issue of appropriate delta flow criteria hasn't really been addressed in this proceeding, but there aren't any analyzed alternatives for appropriate delta flow criteria. And decision 1641 is those limits are based entirely on the existing configuration of delta diversions. So you can go back and look at when the US EPA approved it, and they didn't, they said that it would have to be reevaluated if there were new diversions in the delta. So one of the public interest considerations is fundamentally, have you addressed the legislative requirements to assure that the public interest and the public trust is preserved? And I don't see how that's going to be addressed. And it goes back to, as everybody's saying, we don't even know the amount that would be diverted isn't in the application, the change petition. It's fundamental, and the legislature did mandate in 85086 C2 that the appropriate delta flow criteria, be adopted at the time of the change. It needs to be in the order granting the change petition. And none of that is available. No alternatives have been analyzed by DWR for the single tunnel project. And it has everything to do with the concerns that people are raising. Thank you.
Thank you, Ms. Desjardins. Hold, I've lost my order. I changed my view and lost my ordering. Mr. Krieger, please.
Thank you, Hearing Officer Kenzie. I think I lost my place in line, but I want to just make a short comment here, and I want to largely keep to the procedural questions, or I think the procedural questions that are engendered by the hearing issues for the conference today, and not get into evidence. But I want to simply say that the Delta Conveyance Project has utility now within existing water supplies that are available to the State Water Project under current regulatory conditions, because it will help protect against future water supply losses from climate change and sea level rise. There's another process for total water supply related to Term 7 and beneficial use that involves other State Water Project facilities that are not at issue here. That process will happen, but that is not this process. The Delta Conveyance Project and the petition are not changing regulatory limitations of the State Water Project broadly, and the Conveyance Project would be subject to any future regulatory requirements from a Term 7 process that apply to the State Water Project broadly. So it's simply not necessary here to commingle them in resolving a proceeding with the Delta Conveyance Project petition. So I just want to make that clear from the contractor's perspective.
Thank you, Mr. Krieger, and you're right. I apologize. I think I said I would come back to you, and then I started in on the list, so I apologize for that. I'm trying to think if I have any. I think I understand your points. We'll see if at some point I'd like to take a break because I do want to give myself a moment to think and see if I have any other questions. So,
sure.
But thank you. Ms. Tabor.
Yes, briefly in response to Mr. Krieger's comments, whether the Delta Conveyance Project has utility now is a key and disputed issue in the hearing. So I just reiterate that point. The comment related to the hearing conference issues, the DWR's intent to present evidence of historic use in its case in chief underscores the need to have staggered submittal of case in chief testimony so that the protestants have the ability to tailor their case in chief to this new evidence. And finally, I do think DWR should be required to commit to a date certain when it will submit its petition for extension of time. We were told 2 months ago that it would be, quote, in the near future. I'm not sure what that means, and if we're talking about real time or geologic time, but it's a key issue for protestants and my clients to understand whether there's the potential to have two proceedings proceeding in parallel on the DCP and the petition for extension of time. If the petition for extension of time is dealt with separately, I don't understand what the basis would be for the AHO to defer that pending petition that has been filed nearly contemporaneously with the in regard to the general timelines for State Water Board hearing of these issues to the DCP change petition. And if those issues can be separated, as DWR thinks they can be, I guess we would like to know if that is a potential scenario, because it would be incredibly burdensome for the public. And I'm not sure what the justification would be if that petition for extension is filed to then for the Water Board to sit on that as it did the last petition for extension time.
Thank you, Ms. Tabor. Ms. Baer.
Yes, I'll be brief. I just want to flag California Water Code Section 1390, which states a permit shall be effective for such time as the water actually appropriated under it is used for a useful and beneficial use in conformity with this division, but no longer. This section makes clear that a permit is valid so long as the water was actually put to beneficial use, and DWR had until 2009 to do that. To my understanding, the way we confirm the perfected amount is through a licensing proceeding under Section 1610, which I believe has never occurred. And just to remind everyone again, DWR was explicit in its 2009 extension application that all State Water Project construction under the 1972 permits was complete as of December 2000, and it's going back on that now with what it said in that filing. I also agree that DWR needs to tell us what the maximum historical use is now, and that presenting that in case in chief is too late. Protestants need this information to evaluate public trust impacts, impacts on beneficial uses, and on tribes and on environmental justice communities, water availability. That's just an essential metric. we can't properly assess all of the dimensions of this project without knowing the contours again of what DWR is trying to get approved here. Thank you.
Thank you, Ms. Bear. And there is section 1390. Thank you for that reference. Mr. Brodsky.
Yes, thank you. I just wanted to reiterate Ms. Bear's point about section 1390, but then also section 1701.3 says that the board, after a petition is filed, can make a further request for information to complete the petition. And so I think in this case, that 1701.3 is written exactly for this situation, and that the board should request today that DWR submit the additional information as to the historical use on those existing permits. And that should be a spreadsheet broken down by each permit. What have you put to historical use? So I think 1701.3 obviously gives the board the authority to do that and anticipates this type of situation. And I think it shouldn't be very burdensome on DWR to provide that information. They say they're going to have to provide it eventually anyway. They've been making reports on their usage, so presumably they have this in their computer, and it won't be too difficult to just produce a spreadsheet and give it to all of us.
Thank you, Mr. Brodsky. Mr. Busher.
Just two real quick points. Thank you for your patience with us all today. I think number one, kind of again, zooming back out, right? The reason the DWR has not provided that information to the extent it exists is because the request in this petition was not to divert water at the historical rates. It was to divert more water, right? And so all the analysis is about more water being diverted, not the historical rates of water. And I think that's telling as to where this started as compared to where we sit today. And then the other thing I'll note, I'm a little bit concerned, maybe pre-traumatized about the idea of having two worlds of evidence presented in this proceeding, right? This is a big, complicated issue if there's just one world of evidence that people are arguing about. But if we're arguing about what are the impacts of current diversions through a new facility versus what are the impacts of, and what are the impacts of new diversions through a new facility or additional diversions, like that's gonna, substantially increase the amount of time we have to spend on this and make these issues that are already complex enough, right, really hard to parse apart and to understand, really hard for the board to make an informed decision about if they're trying to compare two competing worlds of evidence. And then the last thing I'll say on this subject is it's not clear to me that the analysis for those two competing worlds of evidence, the legal requirements for whether a new or changed permit should issue for those two competing worlds of evidence is the same. Right. And that's why we started with this needs to be a new application for a new water right, not a change in point of diversion that may or may not increase the amount to be diverted.
Thank you, Mr. Busher. Mr. Brodsky, is that did you have another point, or is that a stray hand still up?
I'm sorry, it's a stray hand, although I did also want to, are we at the point yet where we're talking about staggering the hearings? Because we had suggested, in addition to staggering, that there be a part A and a part B.
Let's come back to that issue. Let's see if we can. It's not. I know all these issues go together, but I do plan to come back to that. You're not missing the boat on that one, so we'll get to that one. Mr. Moore, you're on mute.
Can you hear me now?
Yes, I can. Thank you.
I would just request that you disregard the conclusory assertion of Mr. Krieger, also echoed in DWR's pre-hearing statement, that the Delta Conveyance project, in their opinion, would have utility even if there were a limitation to perfected rights, whatever those might turn out to be when there is evidence considered of them. As Ms. Tabor already pointed out, those are themselves pre-hearing issues. There are also issues in pending litigation, as is the subject of how that relates to the alternatives that DWR excluded in its review and analysis, and that exclusion included all non-conveyance alternatives. So in addressing public trust and public interest considerations, we don't have the basis to determine, for example, what more could be done for seismic resilience and climate preparedness if billions of dollars did not have to be spent on the Delta Conveyance project. The courts will decide whether that works for DWR as a matter of CEQA compliance, but how that squares with the public interest, public trust, and other considerations that are directly before the board remain to be determined and cannot be summarily assumed.
Thank you, Mr. Moore. What I'd like to do at this point for all of our benefit, and Ms. Desjardins, I see your hand is up, but I'd like to go ahead and take a 10-minute break for a variety of reasons, also so I can think, and then circle back. I may have some additional questions, and then I will do a last call on this issues 1 and 2 from the pre-hearing conference notice, and then we will turn to the more, I don't want to say mundane, but they're still hard issues, but this question of how the hearing should actually be structured and go forward. So with that, let's go ahead and take a 10-minute break. We'll return at 11:21. And I would encourage all of you to go off camera and on mute. Welcome back. 11:22, so I'm 1 minute tardy here, but I appreciate the break. I hope all of you appreciated the break. I did have a chance to think whether I have any additional follow-up questions, and I think the only thing I have, and like I said, I will give a chance for others to chime in here, but in terms of this question of the petition for questions with respect to terms 6 and 7, shall we call them, I wanted to ask Ms. Carroll, to the extent you know or can share, what DWR's intent is with respect to the timing of filing a petition for extension of time and what time period that petition would cover, just with respect to the relative efficiencies of these different proceedings is the reason I'm asking, but I don't know if you can provide any information on that at this time.
I hate to answer you with a question, but can I get clarity as to whether you're referring to term 6, term 7, or the collective?
Let's do all of them. How about that? I don't know.
So we're not anticipating filing a separate petition for term 6 and 7 together, right? Our request is to include term 6 in this current change of point of diversion hearing process, because it is related specifically to the construction of the Delta Conveyance project, which is the only construction project that's currently contemplated for diversion and rediversion, right? We said at the initial pre-hearing conference that we would be filing a separate petition for time extension for term 7, and that would be occurring after the completion of this CPOD hearing process. So that's the anticipated timeline at the moment.
Thank you. That's helpful. Let me follow up in this, and the way you envision it is that term 6 would be, well, how about this? And I know I think we talked about this earlier this morning, so to the extent you've had a chance to think about it, I'm not quite sure. But if we took this approach where it is not necessary to amend term 6 with respect to construction for a project that would be limited to the historical maximum use, would that, in your opinion, change the intent such that a future filed petition for extension of time would include both a construction deadline and a beneficial use deadline?
I don't know if we would have to include the construction deadline if we don't have to have it amended now for extension, and this is the only construction anticipated. Would approval of the CPOD petition in itself be in effect approving then the timeline extension for construction only?
Okay, I think I understand. And maybe another way to put this, the envisioned timeline is that a petition for extension of time with respect to term 7 would be filed after this hearing process, but before the project has been constructed.
Yes, because it is going to take quite a bit of time to finish construction of the project.
That makes sense. Thank you. I appreciate that. Is there anything else you'd like to add at this point, or we can circle back?
No, I think I'm good right now. Well, I'll just add that it's not new that we're subject to this historical maximum limitation. We're currently operating under that limitation because the deadline expired in 2009 for term 7. So that fact is not new, nor is it a new limitation. And our water use is currently reported to the State Water Board and has been for many, many, many years. So that information is also not new and has been available to the public. So I just want to stress those 2 points, that this is also our current existence.
So if you've been operating to those limits, well, I guess maybe do you, I'm trying to understand how difficult it would be to get these numbers, because my understanding is that the filings from pre-2009, the reporting was a collective reporting number, not individual to the particular permits. So it makes it difficult to come up with a number. And my understanding through the water fix proceeding was that this number is actually hard to come by and not easy. And I think what you're reflecting to me is that it can be understood just by looking at the reporting made to the State Water Board. And I'm trying to understand what better from my own view is, if you've been operating to this number, does that mean you have the number? You can provide it, tomorrow, something to that effect?
So just to clarify, we're not operating to that number. Our operations are restrained by that number. That's our regulatory.
But you're reflecting to me today, or that you have, DWR has been operating within that constraint, as I understand it. What is the number? What is the constraint number? I mean, do you have that number?
I do not have that number for you today.
But it could be acquired in short order because it's something that DWR has been aware of.
Yes, we would calculate based on the water use that we've reported.
Thank you. I just wanted to make sure, as I am not an engineer, so I don't know how sometimes numbers are hard to come up with and sometimes they're not. So I appreciate that. Let me look to the room if there's anything else on the time extension issue before we move to how this hearing deadlines and discussion of staggering. Mr. Busher.
Yeah, I apologize. I am thoroughly confused at this point because I don't understand. I candidly, I don't understand what the petition seeks to do with respect to changes in capacity or changes in volume of diversion. I understand what the DCP seeks to do with respect to changes in volumes of conversion as a project. But if we're talking about a petition now before the board that is capped at historical use limits rather than the increased capacity that the project analyzed in CEQA, and then a future extension of the time to put to beneficial use the water, it seems like if we're talking about historical uses, that water has been put to beneficial use. I don't understand why we need an extension. And if we're talking about new, it seems like we got to analyze whether that is appropriate in this proceeding, not in some future term 7 extension, over whether we could expand the beneficial use or increase the historical capacity or extend the deadline to put the water to use so that DWR could then put more water to use in the future. And so I'm just thoroughly confused as to what it is that's at issue here in terms of the petition, and then what the future term 7 extensions would need to look like given that. And I would just really like to have some understanding of that before we start preparing case in chief and getting into the weeds of this proceeding. I don't know that that's gonna happen right at today's hearing, but I'm more lost than I started the day.
Let me turn, and I see the other hands, I appreciate that. Let me turn first back to Ms. Carroll, because I think this is a fair, I think I made an attempt to articulate what I thought DWR was attempting to do, but it probably is more direct if I ask Ms. Carroll directly, if you would please just walk us through what DWR intends to have at issue in this proceeding.
So what we want to have at issue at this hearing is the construction of the Delta Conveyance project and the new diversion points that were requested in our petition.
For what amount of water?
We analyzed for more than our existing historical maximum. However, by regulatory constraint, we are limited to that until we apply for time extension. And until the board grants it.
Thank you. I appreciate that. I wanted to turn back to you, Mr. Busher, though. I'm not saying that necessarily answers all your questions, but did that help? Do you have anything you'd like to add?
No, I'll let others speak for a while once I ponder
right.
that. Thank you.
Mr. Moore.
I just want to note what I think is a particularly glaring pattern of evasion here. Unless I'm missing something, DWR was asked about the time frame for filing another petition for extension, and the answer was after. After is not a time frame. After just means not now. Many years have passed since 2009. DWR also made the assertion that it is complying with the 2009 base beneficial use limitation, but can't tell you what a number is or when we will have it or when the public will have an opportunity to analyze. This didn't just come up now. This has been the still incomplete culmination of a long process that has played out before this board of duck and cover with DWR. So in the context of the never resolved protest to the 2009 extension, one of the protests were made in 2010 that identified, quite a few reasons why, on the facts and as a matter of law, there should be no extension past 2009 for beneficial uses. Among them were things that will need to be considered in this proceeding as well, like the failure to exercise the required due diligence, the adverse effects on Delta and other water rights that the protestants argued, would not have complied even with the existing, now quite outdated historical Delta water quality requirements. Also, a failure to explain how much water can be put to beneficial use, a failure to clarify maximum diversions, and harm to the public trust and public interest, among other things. Those were pending before the board for many years. The board never resolved them. Earlier this year, we were informed that the board did not intend to resolve them, apparently because DWR never completed environmental review and the time frame lapsed. So now we have all these unanswered questions that have been literally on the table at least since 2010, and they remain foundational question marks for proceeding that cannot be ducked. The public's need for that information and the boards need to know whether those legal requirements have been met cannot be ducked anymore. They are not peripheral. They're not something that can be finessed by conditions. They go to this fundamental issue of whether there's a water right that can be changed, or as the DTEC protestants suggest, there's an attempt here to make a retroactive change that is not legally available. So this has to be considered before anything else, because otherwise there's nothing they can change from.
Thank you, Mr. Moore. Ms. Bear.
Yeah, I've made most of my points, but just to wrap up questions 1 and 2 here, I will just reemphasize that we need responses from the board on the jurisdictional concerns that I and others have raised, and that are discussed in our pre-hearing conference statement. I have to point out that this convoluted discussion has only emphasized the tortured logic of these proceedings. I think it's clear to all of the protestants here that DWR is jumping through hoops to try and avoid applying for a new water right, which is just what needs to happen here. DWR has tried today to recast this project as something that their materials do not reflect. The project that was subjected to CEQA review already and that was submitted in the petition was infrastructure to capture excess flows that will increase diversion amounts. But that's not what's being discussed here with the suggestion that the DCP doesn't have to operate above historical maximum use. If DWR wants to change the scope in recognition that it's lost the right to that additional diversion amount under Section 1390, it can withdraw and refile. DWR has to inform the public of its entire project and its assessment of the project's foreseeable environmental impacts so that the public is able to fully and fairly participate in these proceedings. Again, I'm representing tribes and historically marginalized communities that will be materially impacted by this project, and those parties can't understand what's being applied for. And that's a problem of justice. And I agree with Eric that we're leaving here with more questions than we started with. I will again remind the board that it is subject to a pending EPA Title VI investigation for the exclusion of communities of color and tribal nations from these decision-making processes, and getting this right really matters. Thank you.
Thank you, Ms. Bear. Ms. Desjardins.
Thank you. I wanted to second Mr. Brodsky's request for the amount that was historically diverted. And I also wanted to point out that it's not just the maximum amount that was historically diverted, but there's a real question because currently about the minimum amount that's diverted, because historically salinity intrusion has limited how much they can divert at Clifton Court Forebay, and we know the North Delta intakes won't have that limitation. And so the question of diversion under very dry conditions where salinity intrusion is an issue, particularly with sea level rise, is a major issue that needs to be considered by the board. And I am very concerned that DWR's proposal to consider Section 7 in a later proceeding evades the plain meaning of Water Code 85086C2 that would allow the board to, for example, mandate minimum flows at Rio Vista year round. That's not mandated, and it's a huge issue. If there aren't those criteria, and we know from the Trump administration that sometimes the projects are likely to be operated to their permit. So I wanted to second Brodsky's request and also say that the operation of the projects under conditions in which you would be limited to how in diverting flows from the South Delta facilities is a key question, and it's something that needs to be clarified before we get to case in chief, because people need to have time to evaluate it and prepare their case. Thank you.
Thank you. With that, I would like to move on to issue number 3. But first of all, thank you for the robust conversation. I know this has been a long morning and we are grappling with hard issues. And this has been helpful to me, although I will acknowledge it's quite complex. I'm not sure if I have more clarity, but to some extent. Let's turn to issue 3, which is I had raised consideration of staggering case-in-chief deadlines. I think some of the benefits of that have been already brought up in our discussion. One would be it would provide DWR an opportunity. DWR would be in the position of presenting, for example, this maximum historic use number, which the protestants would then have the opportunity to respond to after having seen that. I will say, based on my general experience with hearings, I think we would actually enhance the efficiency of the proceeding by staggering the case-in-chief deadlines and staggering the hearing process, because in general, it seems to me the protestants are in this position of responding to minimal information. I realize there's a long EIR and that can be responded to, but I think the protestant's case in chief would be more focused if it was in response to DWR's case in chief. I know DWR has characterized this, or maybe it was state water contractors, as a fairness issue. I guess there's some element of that, but in terms of efficiency, I think we'd actually get through this proceeding more efficiently and have fewer hearing days if we staggered. And so that was part of my intent in thinking about this. Another factor here is, I think an advantage of staggering the deadlines is it sounds to me like DWR is ready to go and would like to have this hearing as soon as possible. That's my understanding. And so we could get started. Whereas I have some concern with respect to the protestants. Frankly, we have another large proceeding and rebuttal is going to be in January and February. So we are going to avoid overlap on those. And I have to figure out how to time that and how to do that because I'm only one person and the protestants are often represented by other humans who are only one person. So that is just a logistical, practical factor that's playing in here. So my thought on staggering the deadlines is one, I think it actually may increase efficiency, although I'm here to listen about and consider why that may not be the case. And then also two, it would allow us to get started with this proceeding sooner. But I will turn first to Ms. Carroll and DWR if you have comments on this, and I will then proceed down the list, if it will. Ms. Carroll.
Thank you, Hearing Officer Kinsey. I know it appears that it would be more efficient to do it that way, but unfortunately, I think that by staggering the cases in chief, we're actually going to create additional steps because essentially what will happen is that the protestants will have an opportunity to present case in chief and rebuttal. DWR will then have to ask for rebuttal. We also had a similar staggering that occurred in the water fix hearing, which if you go back to those proceedings, it really did not create additional efficiencies. And resulted in confusion and longer timeframes.
And let me clarify, but this is what I was envisioning. I was envisioning, assuming we go forward, envisioning that we would stagger the case in chief and then sync up, if you will, for rebuttal, so that we'd be back on track at one deadline, right? So I don't know if you have any, I realize I didn't expressly state that in the pre-hearing conference notice, but that is what I had been thinking. There are other possibilities, and we could actually address those possibilities later, but did you want to respond to that piece of it at all?
Yes, please. I mean, I think in theory and in writing, that would be great, but the problem is there's still going to be the opportunity for the protestants to use that case in chief as rebuttal. They're not going to necessarily abide by the direction that rebuttal be withheld until the deadline that's set forth in the hearing notice. I can see the temptation to do that. We're still going to then have to ask for rebuttal and a prolonged proceeding in the pleadings.
Well, and maybe clarify that for me. You would have to ask for rebuttal.
So essentially, we would not be allowed the same 2 bites at the argument that the other parties are allowed if we aren't given an opportunity to then respond again at the end. It's the way that the staggering would occur is we've already put forth our petition. We've already put forth our amendment request to put forth what we want to be in the scope of this hearing. Then we would be putting forth our case in chief with our evidence, which could then be responded to in the other party's case in chief. And then also there would be a rebuttal deadline, which then everybody would be allowed another second chance at rebuttal argument, but that would be DWR's first opportunity.
But you would have the opportunity, so you just take a bigger bite of the apple, right? I mean, is that, you don't see it as working that way?
Not necessarily. I think in theory and in a perfect world, yes, but unfortunately the world we live in is imperfect.
I understand that. Thank you. Thank you, Ms. Carroll. Mr. Krieger, do you have any comments on this?
I don't. I'd just like to echo what Ms. Carroll just articulated with respect to DWR's position. The state water contractors view it the same way. And we expressed that in our pre-hearing statement, and we would simply reiterate that here.
Thank you. And actually, Ms. Carroll, this may be, I want to present this question fairly, but if you put yourself in my position and think, well, if there's a choice between starting the hearing, I don't know, in February, in April versus February, and having a consolidated case in chief, which would be DWR's preference, to start sooner or to start with the consolidated case in chief? I mean, still in the spring, but with the consolidated case in chief.
Procedurally, I would say a consolidated case in chief. However, timing is very important to the department. So as early as we possibly could do that.
Understood. Thank you. And just to caveat my comments, I realize we're having this discussion assuming the proceeding is going forward with the current scope. I realize if there's a change in the scope, this is a separate, the schedule would need to change, but I'd like to have this conversation now since we're here, setting aside issues 1 and 2 that we talked about in great detail earlier. So I just wanted to make that clear that this is nothing has been decided at this point. Excuse me, while I turn through my list. I believe next I have Ms. Tabor. Do you have any comments on this?
None beyond what we've made and what is in our pre-hearing conference statement.
Great, thank you. Maybe I'll just look to the room. Are there others who would like to chime in on this issue of staggering? Ms. Desjardins, your hand went up first, please.
Yeah, I just wanted to point out, I was looking up the change petition, but I believe that the Department of Water Resources in the change petition refers to information that will be presented in their case in chief. So this was just a shell game. Said, oh, well, the information's in our change petition, so we don't need to stagger presentations. And then I think if you go and look closely at the change petition, it says the information will be provided in our case in chief. And I would point out that smaller organizations don't have the resources that the department has. They don't have a team of multiple people, and it takes a while to evaluate the information. I would argue that this is manifestly unjust, and there are court decisions that require due process in administrative hearings, and particularly where rights such as tribal rights or property rights are concerned. And I'm very concerned that the shell game that the Department of Water Resources is proposing violates those due process rights. I'll get you the citations. Thank you.
Thank you, Ms. Desjardins. Ms. Thompson, please.
Yes, thank you. I think just to build off of that, it's important to emphasize that in this situation, fairness and equity, it cuts towards protestants, not DWR. Just to reiterate the idea that the DWR is well-resourced, while many of the protestants are, again, disadvantaged communities and tribal nations who don't necessarily have the same number of attorneys, the same amount of time to be giving and are to be giving to this particular proceeding, especially considering that they're dealing with other proceedings as well at the same time. When looking at the case in chief deadlines and the hearing process, like these are things that are all affected by the fact that many protestants have already brought up, but the public just can't understand what DWR is asking for. And before we can move on to like understanding what these deadlines should be or how even the cases in chief should go, we need to understand DWR needs to make it clear what they're applying for so that protestants can understand what framework that they're operating under, whether that's an extension of time or whether that's a new water right. I mean, under any of these scenarios, however, there are these fundamental jurisdictional issues that just mean that the current deadlines for submittal and the current hearing date are just unworkable. And to quickly re-highlight some that have been brought up today, that would be the fact that protestants are missing key information that they would need to build cases in chief, that there are also ongoing proceedings that would affect this proceeding, such as the update to the Bay Delta plan, as well as the fact that the board is being investigated by the EPA for discrimination against tribal nations and marginalized communities regarding inclusion in decision-making processes. And again, fundamentally, the protestants just have no idea what DWR is asking for. And given the fact that the board needs to work through all of these open questions in order to give parties like fundamental issues that they will need to be addressing, again, these deadlines are just not workable. Once we do get to the point of case in chief, which again feels premature, the hearings should be staggered. And this staggering goes directly to the fact that DWR is the party with the burden of proof in this case, as well as the party whose application and petitions that we're talking about. We're dealing with complex legal and scientific and equity issues that need to be addressed carefully. And if these proceedings are allowed to be rushed, then it's the Bay Delta communities and the tribal nations who will bear the consequences of these decisions for generations. Thank you.
Thank you, Ms. Thompson. Mr. Busher.
Yeah, so Ms. Thompson covered most of what I wanted to say. I think the only point I would drive home is, as we sit here today, the only thing the hearing office needs to do with respect to case in chief deadlines and hearing dates is to vacate the January deadlines. Because, I mean, if DWR wants to submit case in chief in January and the hearing officer wants to, I won't object. But I think we got to vacate those January deadlines. It's clear that those are not going to be workable on a broad scale. And I'm real hesitant to set future dates in April or otherwise until we know what it is that we're considering here. And I think that that's the right step, is vacate the current ones. Let's resolve the procedural issues, the jurisdictional issues that have been raised. We're going to have an ITP permit and an updated Bay Delta plan documentation, I think both by the end of the year. And then, sometime in 2025, we can have a pre-hearing conference based on all of those, once those jurisdictional and timing questions are resolved, and set a schedule to the extent one's appropriate, or DWR can file a water rights application and there will be a schedule set on that. But I think trying to continue to set the schedule before we get all this stuff resolved is, going to result in a lot of people holding a lot of dates on calendars that don't need to be held now and that aren't actually going to happen. And I don't understand how to prepare a case in chief for a shifting project if the DWR is not willing to provide the additional information until it presents its case in chief testimony. So I think that's where we stand today.
Thank you, Mr. Busher. And I had written this down and I should have said it earlier. I think it probably isn't self-evident because you need to hear it from me, but we will not have policy statements on January 16th, and we will not start the evidentiary portion of the hearing on January 30th. I don't think there's any scenario under which that works or that happens. And it is the intent of the board to provide more guidance about exactly what the schedule will be as soon as possible. I realize, 2025 is rapidly approaching and we all have a lot of things we need to do and put on our calendar, but I can at least say that with conviction. So maybe that's a small help. I'm not sure what order. Ms. Desjardins, was your hand still up from before? Yes, I think so. Mr. Moore, please.
I believe that Mr. Schutz and Ms. Meserve were before me. So
ahead of you. Oh, Zoom doesn't keep track for me. That's terrible.
I inadvertently lowered my hand and raised it, and Zoom is unforgiving on those things, but I think I was next.
Please, Mr. Schutz.
So I think addressing the narrow question of staggering, I think one of the main things we saw and one of the problems we had, the big problems we had in water fix, was the fact that we had a shifting project, and even without that, we didn't fully understand what the project was that DWR was proposing. And one of the things that happens in those kinds of scenarios, DWR has presented a large amount of material. But there are some things that don't fully become clear about what they're proposing, such as whether or not they're proposing to limit the diversion as such to existing historical use at this time. That's just a sort of glaring example, but there are other things that come up. And sort of on an informational basis, I think it's important that we understand what DWR's projects are. Otherwise, a lot of the testimony from the protestants tends to get somewhat off point. And I understand the concern about rebutting existing, rebutting what DWR has said, but looking at it a different way, it's simply responding to what they're actually proposing. And I think it's the informational part of this, given the complexity and the volume of information available, that suggests that it would be appropriate, simply for the well functioning of the proceeding, to let DWR make its presentations, and so that we understand what exactly they're proposing to do.
Thank you, Mr. Schutz. And Ms. Meserve, I'll turn to you.
Thank you, OSHA Meserve. Yeah, I guess, I mean, I'm troubled by the idea of having a deadline for any party, including DWR, at this point, because I think what is in the petition that was filed in February is not what we're hearing is the proposal now. And so I guess before we set a schedule, any kind of schedule, it seems like we need a clear idea of what the petitioner is proposing. And it seems like that may entail further amendments to the petition, setting aside, we don't think that you can do the time extension with a minor amendment. And, you know, my concern is that the way this project is being marketed to the participating districts is that this is how you don't lose water supply in the future, right? And intrinsic in that is that it would be operated differently in the future. And also there is benefit cost analysis going on in terms of what could be diverted. And that goes to a variety of impacts on legal users of water and beneficial uses, as well as public interest considerations, how much water is actually diverted through it. So it just troubles me to think about making assumptions about how a facility would be operated that are not consistent with the physical capacity of that facility. And that's why I gave the example of the amazing capacity of this facility to move a lot of water in a year, for instance. So, I mean, I think having a focused hearing is important for efficiency, and having us on the protestant side respond to what the petitioners actually want to do is super important. And I'm hearing a shifting version of what petitioners want to do. They wanted to just go forward without dealing with the fact that the time limit to construct and put to beneficial use has long passed. Now that DWR didn't feel it could, you know, get away with that, it's trying to shift again. And all that's different than what we saw in the environmental review. So, you know, I don't want to waste anybody's time here, including the water board's time. And I fear that's where we're headed if we set a schedule without getting clarity on the proposed operations and a range of operations that's for the entire life of the project, not just interim operations. So that's my concern with trying to set a schedule with what we have in front of us today. Thanks.
Thank you, Ms. Meserve. No, I think you answered it. No, never mind. I wrote down a question, then you answered it. So I got it. Thank you. Mr. Moore.
As usual, it's a tough act to follow right after OSHA Meserve because she gets right to the point. And so I will just note my complete agreement with her and my other protesting colleagues. CWIN and the joint protestants have already articulated the multiple reasons why January in particular, but the early months of next year are likely a non-start for the proceedings anyway. There is a clear fundamental ambiguity right now in what DWR is actually proposing, and the pretty significant likelihood that what could come out in parallel or within months from the Delta water quality update proceeding would render monumentally irrelevant whatever might be tentatively decided in that period. Should matters proceed, before we can even get to the case in chief. We can have, I suppose you could call it phase 0, this time where we try to get to the bottom of whether the nature of these proceedings really is about a change petition as claimed, or is an indirect attempt that needs to be made more express to get a new water right. When matters, assuming that matters are ready for prime time at some point in the fairly near future, and the board does go on to schedule matters in the case in chief, we appreciate the recognition today that that will not go on in January. When it does, we certainly agree with the premise that having staggering when the time comes would make sense. The DTEC protestants hit on one of the key reasons for that, which is that DWR has the burden of proof. The benefit of staggering, I think, is very much amplified by the discussion that we've had today about this related issue of the perfection or not of beneficial uses, and the information that thus far it seems like likely does not exist in terms of analysis and context, but certainly the public has not had an opportunity to review about the state of beneficial uses and how they intersect with what DWR requests. Finally, I don't want it to get buried in the discussion. The joint protestants did make the request that later, when the time comes to proceed on the merits, if the petition is not by then simply rejected outright, there should then be phases relating to water rights matters and the other stuff. Anyway, thank you for considering our concerns. DWR has no standing or leverage at this point in creating a false sense of urgency about all this, particularly given things like their recent loss in the validation proceeding that casts doubt on the ability for financing, and their loss of a preliminary injunction motion relating to proposed geotechnical activities. Due in part to their own self-inflicted errors, it will be quite some time before these other matters are sorted out. So the board should take the time and opportunity it needs to make sure that these proceedings do what they need to protect the public interest and public trust.
Thank you, Mr. Moore. Mr. Cho.
Thank you. Just briefly touching on the narrow question about a staggered approach and what that would do logistically to the proceedings. Ms. Carroll noted that there could be some unfairness about the need for additional rebuttal, but I just wanted to point out that if all parties are required to submit evidence at the same time, that it all but guarantees an extremely bloated rebuttal portion where protestants will only then at that point have the information they need to actually address how DWR proposes to operate and conduct the project. That will also result in a good deal of unnecessary time and energy and resources spent at the outset to prepare cases in chief that cover the broad spectrum of potential scenarios that could arise.
Thank you, Mr. Cho. Ms. Desjardins, you've had several opportunities, but
Sorry, I just had an additional thought, which
Sure.
was when Ocean Reserve talked about conditions on operations for the life of the project, DWR really hasn't proposed that, and you might want to consider the precedent of the board after they granted the State Water Project petitions for Decision 1275. They had a second proceeding to consider permit terms and conditions. But Water Code 85086 does require that there be some permit terms. And if you look at the history of the projects, the permit terms that are lasting. The Water Quality Control Plan is updated, you know, periodically, but the permit terms are much more lasting, and they're what really address the public interest and public trust issues. So I wanted to ask that you seriously consider that as possibly another phase. Thank you.
Thank you. Mr. Brodsky.
Thank you. So in terms, just sticking strictly to the staggering. So this new idea that the North Delta diversions may be operated only within the constraints of existing historical use, if you put that together with the operating criteria of the DCP, that supposedly the North Delta diversions will only be operated on days when at least 3,000 CFS is being diverted through the South Delta diversions, right? Which was something that was added to the DCP to allay our concerns about the, you know, the harmful effects of water effects decreasing freshwater flow through the Delta. If you put those two things together, will there be any water at all to be diverted through the North Delta diversions? Or if so, what will that look like if you subtract that 3,000 CFS per day from historical limits? What is the diversion going to look like through the North Delta diversions? We don't have that. So I think that's just another reason why DWR needs to present their case in chief. We're back first, staggered, before our cases in chief are due. We're really back to water fix, where they even admitted we don't know what the project is. We'll define the project when we present our case in chief. And that's why cases in chief were staggered in water fix, because protestants had no way of knowing what the project was. That's where we are here again. And so I think that that requirement, supposedly, that they're going to adhere to, of only diverting through the North Delta diversions on days when they're diverting 3,000 CFS through South Delta, is another argument as to why we need to see their case in chief to see what this project is going to look like.
Thank you, Mr. Brodsky. At this point, I know we're coming in on the lunch hour, but I would like to look to the room to see if there are other procedural issues. I know many of you have already raised some other procedural issues, but is there anything else that needs to be addressed or should be addressed today? Mr. Wright.
Yeah, can you hear me?
Yes, please.
Okay. Yes. The Sierra Club California and our 5 other protestants in our group, we joined in the joint response, but we also did a separate written statement that you said you got at the start of the hearing, confined to one issue. And that's the need to complete updating the Bay Delta plan before starting the hearing on this project. Now, we talked in our written statement about the Water Board staff report substitute environmental document that the Water Board issued on September 28th last year. So what we're talking about is the Water Board's own experts. And what they say is, and I'm quoting, current Delta outflow regulations are far below protective levels. And that's in chapter 5 at page 528. That's not us saying it. That's the Water Board's own experts saying it in a substitute environmental document. And so we close our written comments with, it makes no sense to commence the hearing process when the current governing standards are far below protective levels, but on the verge of being updated. And we've heard today, if I heard correctly, I wouldn't I believe I heard correctly, DWR, when you posed the question, well, if you had your choice, February or April, I think I'm hearing April. Well, under the overview that the Water Board issued on May 30th of the Bay Delta Plan update process, they could be ready to approve the final updated plan for the Bay Delta in April. I mean, this is like, we're talking about the regulatory standards that are a quarter of a century out of date. The Water Board said back 7 years ago in 2017 that they're too low to protect the required things that need to be corrected. We've seen that on July 29th, 24th, that's of course talking about the endangered and threatened fish species, but we're also talking about public health to Delta residents and users. And that includes some of the highest rated environmental justice communities in the state of California. On July 9th this year, 2024, the Water Board issued a danger advisory because of the hazardous algal blooms in portions of the Delta and said this is a danger to people, to human beings. We have that the plan, the alternative recommended by the experts of the Water Board, calls for increasing flows and reducing exports. They actually give specific numbers. And we cited those from the bottom of page 3 of our written statement over to the top of page 4. Very substantial increases in flows and very substantial reductions in exports. But the same experts, the Water Board's experts, then pointed out, in stark contrast to the requirement to reducing exports, this Delta Conveyance project would actually reduce Delta outflows by 758,000 acre feet in wet years.
So, Mr. Wright, I want to be careful.
1,061,000.
Mr. Wright, I want to be careful we're not straying into the substance. I understand. Make sure your point is related to the procedural point, which I know you're making here with respect to the timing of this proceeding and
Yes,
the Bay Delta
absolutely.
Plan update.
Absolutely. 1,061,000 acre feet in above normal years, 649,000 acre feet in below normal years,
Mr. Wright,
326,000.
Mr. Wright.
Well, it is related. It is related because the first thing that we need to see when DWR files its opening papers is where is the water going to come from to reduce exports as called for by the Water Board's experts, and at the same time accommodate increasing exports, which the Water Board experts say their project will do. Where is that water going to come from? We need to know what they're going to say about that before trying to figure out what our case is going to be. It's, for example, you heard from Ms. Thompson about the financial burdens for some of the parties, including environmental justice communities. And it could be that it might be possible for some of the protestants, when the plan is updated, to just say, well, as a matter of law, this project can't go forward because it's not consistent with the Delta plan. On the other hand, if the Water Board goes the way of the voluntary agreements, well, clearly I think everybody is going to need some experts. Roger Moore this morning spoke about the possibility of a stranded asset. Ratepayers, another name for them is California homeowners and renters. They're entitled to know before billions of dollars get transferred from them to the contractors who would build this project, how much, if at all, could this project actually operate before those billions of dollars are taken from the homeowners and renters to transfer over to the contractors. They need to know that. So it seems like proceeding before the Bay Delta plan is updated is kind of like what goes on around the country these days. Alternative facts, alternative universe. We don't know what the facts are. We don't care what they are. The regulatory standards are the starting point for you and the board to evaluate this project. And now we get the point that the water board could finalize the standards as soon as April. It just, again, it makes no sense to start the hearing process when the water board is and should be, and has said it is really, on the verge of updating the Bay Delta plan. And that does it for me, unless you have some questions.
Thank you, Mr. Wright. Thank you for your comments. Mr. Cho.
Thank you. I'd just like to reiterate the request that my colleague Kevin O'Brien made at the August pre-hearing conference, that when the AHO does settle on a schedule for this hearing, that that you consider including a site visit to the proposed intake locations, as that's quite critical to our clients, that that you see the setting and how those local impacts will be felt by the folks there.
Thank you. Thank you for reminding me, Mr. Cho. I appreciate that. Mr. Moore.
As reflected in the discussion this morning, whatever your perspective, and there have been various ones, it is clear that the subject of a potential extension or not in the existing permitting deadlines, including not only term 6, but term 7 relating to beneficial uses. Those things are at minimum closely intertwined with the issues here and then the sequence in which they will be presented. The last thing on my procedural list that I just want to make sure is thought about and considered is the issue Seawin raised again in its most recent statement, that DWR is not disclosing its withdrawal of its extension petitions from 2009 were in violation of ex parte rules and considered what at the very least is a potentially controversial issue that related to things that protestants have raised. And we appreciate that board staff have in effect brought in the extension issue by the way that it has framed the issues for this pre-hearing conference and talked about them. But I did want to come back to that subject because unless it's resolved and made clear what needs to be disclosed within the proceeding, there will be a real risk that whatever DWR may or may not decide to do later on the extension front, which is it announced it is, consider something it can do as a separate matter, will be done without informing all the protestants and participants in this proceeding what it is doing. So in the interest of transparency and clarity, I think it is important to make clear that whatever is done in that regard or other matters that fall within the criteria for disclosure, that those be done within this proceeding so that we do not have that risk that there will be matters closely related to what we are doing here that for which word will not get to all of the participants in this proceeding.
Thank you, Mr. Moore. We may want to deal with that more going forward. I do know it is fair in these proceedings to set expectations, or helpful, set expectations about what is or is not appropriate topics for conversation outside of the hearing context or communication. I will say in this particular case, at least with respect to me, there wasn't any, even if it were construed this way, but there's no ex parte communication, because first I heard of it was when it was attached to one of the protestants' documents. So in that respect, that didn't occur. But I think fair enough. The point's still well taken that if there is communication with the board and treating the board as, assuming the board has a collective mind, which it doesn't always, not everything gets conveyed, that there should be some expectations about what should be disclosed to the service list and whatnot. I'll give that some thought and see if we can articulate that better going forward. So I appreciate that. Ms. Desjardins, is that an errant hand, or do you have something else?
Yeah, I just had one more with respect to Bob Wright's request. I know everybody who represents a beneficial use in the Delta is very concerned about the update to the Delta Water Quality Control Plan, and that will give a lot more information about the initial operations of the project. But another hearing issue is the long-term operations under climate change. And that is something that Water Code Section 85086 C2 is partly designed to address, is actual permit terms. And my protest is related to the adequacy of the analysis. And DWR is not to date responded to that protest. And it is important. We are seeing, accelerating climate change impacts, heat waves, droughts, extreme precipitation. So I urge you to, in your thinking about the hearing issues, to understand and not conflate the two. Thank you.
Thank you, Ms. Desjardins. It's been a long morning. Are there any other issues we should address before we close? Ms. Carroll, please.
Just one clarification. We currently have a third pre-hearing conference set for December 16th. Do you envision keeping that one on schedule to address these various procedural issues that have been raised? You also said at the beginning of the hearing, we'd probably address additional matters.
Thank you. Thank you for that point. I'd like to keep it on calendar. My intent is to keep it on calendar for now. It may be once this, so please do hold that date. As what I envision is in any amended hearing notice or procedural ruling that comes out of this, then I'll provide clarity whether we're planning on that December 16th date, if there are issues to be addressed at that time, or whether we take that off calendar. But if you would please keep that hold, I'd appreciate it. And I appreciate us holding this date, so it worked out that way, that we can all meet. It's a lot of people to get together, so I know advance notice is important. Mr. Busher.
I just had one other unrelated question. I noticed there was no human court reporter here today.
Right.
Is that the plan going forward? Is there a plan for court reporting services for this proceeding? Having read through several of the AI transcripts from the site's proceedings, sometimes it's useful, sometimes it's not.
Well, they're usually useful. It's the degree of utility.
Yeah, fair enough. Once you figure out, what certain words mean and how calcin gets translated into whatever is in the transcript, it's more useful. But I didn't know if there was a plan for having court reporter services at these pre-hearing conferences or at the merits hearing if we ever get there.
So I think two things. One is I think going forward we will likely, I think it is useful to have a court reporter for the pre-hearing conferences. I think the thing to do here will be to get an official transcription that's not Zoom, have a person do it so it's sensible, because we discussed so many matters that are procedurally important, and it seems to me that it would be helpful for everyone involved to have that. in terms of the hearing itself, of course, court reporting is a significant expense. My intent there would be to discuss it further. I don't want to make any decisions in advance, but I think likely it will be up to the participants in the proceeding to retain a court reporter if that's helpful. And I think it would be helpful, extremely helpful. But that merits further discussion, as you know, Mr. Busher, from this other proceeding. I think that merits further discussion going forward as we get closer to an actual hearing start date. But I will represent that I think my intent going forward would be for pre-hearing conferences and for the policy statement day that the board will retain a court reporter for that.
Thank you.
Thank you. I'm looking to the room with a pause. First, I just wanted to appreciate, thank and appreciate all of you for your constructive participation today. I know this was a long morning. I know these are difficult issues and they're detailed. And this certainly, as I mentioned, has helped me. And I think it was worth the time to carefully sort through these and take the time now to, I think, Ms. Meserve, I liked your phrase, to set the table. So I appreciate your time and everyone's courtesy and professionalism in the discussion today. And if I see nothing else with that, going forward, I know we all need clarity and scheduling. I'm planning to get further direction to you as soon as I can. I need to digest all of this information. Let's see, what is 17th? There's a big team with the State Water Board too, as you can imagine. It's difficult to get us together. So it's difficult for me to make a representation as to how soon we will have additional information out. But it would be in the next few weeks. And I will commit to doing it as soon as possible to provide more clarity. And with that, thank you again.